The work of the newly established Federal High Court Insolvency Unit, to mention just a few, all of which will be anchored and driven by industry experts, as well as renowned professionals and colleagues to maximize impact. Each session is designed not just to engage, to exchange knowledge, but to provoke thought, inspire action, and strengthen our collective resolve. By the close of this conference, we will not only have debated the issues, but also charted clear pathways for practice, policy, and reform. We are especially honored to have members of the judiciary in our midst, as their role in interpreting, applying, and strengthening insolvency law cannot be overstated. Their commitment will determine whether insolvency in Nigeria evolves as a tool of last resort or as a credible instrument for business rescue and commercial justice. This conference is therefore more than an event. It is a commitment to shaping a system where insolvency practice not only resolve disputes, but also preserve businesses, protects jobs, and strengthens our economy. And as we look forward to days of robust discussion and exchange, let us also participate tomorrow's gala night, which will round off this conference in a celebration of culture and fellowship under the theme Afro-Chic Royal / Afropolitan Elegance. You can only get to understand that if you are here tomorrow evening. It indeed promises to be an evening of beauty, connection, and shared pride in our African heritage. We will also be glad to see the judges around. I must thank our general sponsors and partners for their invaluable support, our distinguished keynote speakers, session chairs, panelists, and all the experts who will be leading our discussions. Similarly, I extend my immense gratitude to the BRIPAN Executive and Council, and especially our President for their steadfast guidance. Finally, I commend the members of CPC for their tireless commitment to making this conference a reality. When lawyers begin to talk about zero budgets, you know there is trouble, Abby. On behalf of the Conference Planning Committee, I again welcome you all to this conference and wish you a most rewarding and enriching experience. Thank you very much.
Thank you so much, sir. Ladies and gentlemen, please put your hands together one more time. A lot of work went into this, into ensuring that this day is a success, and you agree with me that it is just the opening ceremony, but we can attest to the fact that we have definitely recorded success this year. We don't need to wait till the end of the conference to realize that it has been a successful BRIPAN Conference 2025. So please put your hands together one more time for Mr. Chair, and of course, everyone on the team that has worked tirelessly. I'm on one of the WhatsApp groups, and the communication just keeps going on and on. 1 a.m., 2 a.m., 3 a.m. Information is flying, and I'm like, these people don't sleep. It took a lot of work to make this happen, and indeed, we are extremely proud that it is a success. I do not know. I would like to confirm if we have a representative of the MBA president in the room today for the goodwill message. Okay. Please put your hands together. Please put your hands together. You're welcome, Ma. Okay.
Good morning, distinguished ladies and gentlemen, my Lord, Senior Advocate of Nigeria, and other distinguished ladies and gentlemen. My name is Bolatumi Anmashaun. I'm the second Vice President of Nigerian Bar Association. My president is supposed to be a welcome address. So I welcome all And like somebody said, I'm wearing two caps here because I'm also a member of BRIPAN. I think I became a member in 2011, and I'm overdue to be a fellow. Looking at the topic that we have, focus on deepening insolvency tools for resolving commercial and financial challenges of business. If you look at Nigeria today, we have a lot of businesses closing up, just like people are jackpotting. Business are also closing down. And when we look at the problems that they have, thank God that we have among our members, we have accountants, we have lawyers. So we are problem solvers. We should be able to help these businesses. And what is the problem that we have? Harvests are ripe, but laborers are few. So I believe that when we have more of our members reaching out to these businesses, we have more businesses because we are looking forward to a better Nigeria, and we are the ones that are in charge. We are the ones that can contribute a lot to the betterment of Nigeria. We are problem solvers. We should be able to find solutions, and we have combination of experts in this all. And I believe that at the end of this conference, we have something that will not just be talking about the tools, we'll be able to apply the tools. Thank you very much. Have a robust conference. And as they are talking about that one tomorrow, I believe everybody will be here just to put the icing on the cake. God bless you.
I do not know if it struck all of us, but I don't know if we finally got a theme for next year. The harvest is ripe, but the laborers are few. Oh yeah. So I didn't really know that the jackpot syndrome was also affecting this industry. It's amazing. So next year we should be discussing how to increase the the workforce. Thank you, sir. How do we grow the workforce? How do we sustain it? All right. Thank you so much, Ma. I'd also like to confirm if we have a representative for the chairman MBA Lagos in the room. Okay. If we do not have anyone in the room representing the chairman, please kindly, I'd like to reference the address, the goodwill message in the brochure. You find it in the brochure. Thank you. At this point in time, we'd like to take our first keynote address. In an industry that is greatly, would I say, dominated by a particular gender, it is always exciting for me as a woman to see women thrive in industries that are majorly dominated by the opposite sex, by men. And so today, it is my utmost pleasure to welcome our first keynote address speaker in the person of the Honorable Justice Victoria Nwoye of the Court of Appeal, Nigeria. Please put your hands together. Permit me to be partial, but please a resounding welcome as she takes the podium. Thank you very much.
Good morning, everyone. I'd like to, first of all, stand on the already established protocol as established by the President, the learned senior advocate, Ihe Kwazo. It's not that I'm shocked that I have to stand on something, but I just have to stand on it so I don't make edits. My Lord, I realize you're here. Welcome, my Lord. Like I said, my name is Victoria Nwoye, and it is an honor and privilege for me to stand before you today to deliver the keynote address on a subject that lies at the heart of economic resilience and sustainable enterprise, which is the deepening of the insolvency tools to resolve commercial and financial challenges confronting businesses in our time. In an era marked by global volatility, be it geopolitical tensions, supply chain disruptions, inflationary pressures, or technology upheaval, businesses face unprecedented financial strain, be it small enterprises or multinational corporations. The ability to navigate distress is no longer a peripheral concern. It has become central to our survival and growth. Insolvency frameworks are not merely legal instruments. Rather, they are what we call economic stabilizers. When properly deployed, insolvency frameworks can do the following: rescue viable businesses from collapse, reallocate capital to more productive uses, protect jobs and supply chains, ensure that there is equitable treatment of creditors. It can also promote transparency and accountability in corporate governance. Insolvency, though it is the inability of a company to pay its debts, it is not the end of the road, but it is rather what we call a recalibration of economic relationships. Across many jurisdictions, insolvency regimes remain underdeveloped, overly punitive, and inaccessible to the very businesses that need them the most. The key challenges include limited access to restructuring tools for small and medium enterprises, which form the backbone of most of economies. There is also over-reliance on liquidation, often destroying viable businesses that could have been saved. Lengthy and costly procedures that deter early interventions and insufficient coordinations across borders, especially for multinational firms. These are gaps that are not just technical, they are existential. They determine whether business in distress becomes a story of recovery or a cautionary tale. Nigeria, like many emerging economies, faces a paradox. On the one hand, we have a vibrant entrepreneurial ecosystem and a growing private sector, while on the other, we grapple with high rates of business failure, weak economic mechanisms, limited access to structured insolvency remedies. The Company and Allied Matters Act in 2020 introduced commendable reforms, including provisions for company rescue and business recovery. The transformative shift in Nigeria's corporate insolvency landscape by the Act in 2020 is a major departure from the previous liquidation-heavy regime. The rescue provisions introduced, among others, company voluntary arrangements. This is where there is a contractual agreement between the distressed company and its unsecured creditors to restructure and repay debts over time. There's also administration, where an insolvency practitioner is appointed to manage the company's affairs with the simple goal of rescuing it as a going concern. This process offers protection from creditor enforcement actions, and the administrator can restructure operations or sell assets to maximize returns for creditors. There's also the scheme of arrangement. It is a court-supervised restructuring plan involving creditors and shareholders. This aligns Nigeria with global best practices, especially with the United Kingdom Insolvency Act of 1986. But despite all these innovations, the practical application of these provisions remains uneven. Many stakeholders, judges for instance, are included, lawyers, insolvency practitioners, and regulators are still navigating the contours of these new tools. Judges are the ultimate interpreters of statutory provisions. The understanding of the intent and mechanisms of tools like the company voluntary arrangements, administrations, and schemes of arrangement will shape how these tools are applied in practice. There is no gainsaying that a well-informed judiciary ensures uniform application of insolvency laws across jurisdictions. This builds investors' confidence, reduces forum shopping, and enhances Nigerians' reputation as a business-friendly environment. Modern insolvency frameworks rely on timely judicial intervention. So judges who understand the urgency and the commercial realities of distressed businesses can expedite hearings, approve moratoriums, and support restructuring plans more effectively. We therefore need to deepen the tools of insolvency, which incorporate all players to build a more robust and responsive insolvency ecosystem. We must pursue reforms that are bold, inclusive, and forward-looking. And in that regard, I propose 5 strategic priorities. 1, to expand preventive restructuring framework by introducing mechanisms that allow businesses to develop what has already been the improvement in the Act of 2020 of the CAMA 2020 to ensure that there's flexible, court-supervised, and out-of-court arrangements in place. 2, empower small and medium enterprises with tailored solutions. This is by developing simplified insolvency procedures for small businesses. We reduce costs, streamline timelines, and access to professional support. Thirdly, promote rescue culture over liquidation. That is a shift from the narrative from punishment to rehabilitation. Encourage a turnaround strategies, debtor in possession financing, and stakeholder collaboration. 4, leverage technology for efficiency. Digitalize insolvency filings, automate case tracking, and use artificial intelligence to flag early signs of distress, making the system more accessible and transparent. 5, strengthening cross-border cooperation. This is harmonized insolvency laws and protocols across regions to facilitate smoother resolution for multinational firms and foreign creditors. Now, the Business Recovery and Solvency Practitioners Association of Nigeria, BRIPAN, plays a very pivotal role in strengthening Nigerians' financial and legal infrastructure. So there's therefore need for the insolvency practitioners who operate under intense scrutiny to ensure that there is proper discipline. The key areas are to ensure that fees charged are reasonable, proportionate, and well documented. A valid fee resolution alone is not sufficient. Record must justify the time, cost, and the decisions taken. 2, record keeping. Maintain comprehensive records of all actions, decisions, and time logs. This should allow an informed third party to assess the appropriateness of the conduct. There's also staff utilization and cost efficiency. Assign tasks based on complexity and staff grade. There's also compliance with accreditation standards. Adhere strictly to qualifications, competence, and ethical standards set by the regulatory bodies such as the Corporate Affairs Commission. On this note, I was so happy when I was told by the President, Leonard Essien, yesterday that for you to become an insolvency practitioner, you must be licensed. So that doesn't mean that anybody can just come up and say, I am an insolvency practitioner. ensure anti-money laundering law policies are up to date and followed rigorously. Non-compliance, even without penalties, can trigger advisory notices and reputational damage. Now, when all these things have been done by the insolvency practitioners, other stakeholders too, like the government, regulators, financial institutions, legal practitioners who are not practitioners of insolvency practitioners, and business leaders also have a role to play, as reform must be co-created and not imposed. We must listen to the voices of entrepreneurs, creditors, and workers. We must build systems that are not only legally sound, but economically humane. Imagine a business environment where failure is not fatal, where entrepreneurs can take risk, knowing that there is a safety net, where creditors recover value through collaboration, not confrontation, where insolvency is not a stigma, but a second chance. This, I say, is not an utopian dream. It is a policy choice, and it is within our reach. As we engage in dialogue today and tomorrow, I urge each of us to think boldly, act collaboratively, and innovate relentlessly. The future of business recovery lies not in the tools we have, but how deeply and wisely we wish them. Let us commit to deepening our insolvency tools, not as technical exercise, but as moral and economic imperative. Let us build systems that reflect the dynamism, complexity, and humanity of businesses we serve. Thank you very much for this opportunity.
Thank you, Mel. Please put your hands together. Wow. The standing ovation is in order, ladies and gentlemen. Please put your hands together. Thank you. A big thank you to all the gentlemen on the table where the honorable is seated. Thank you for that honor. It's time for the second keynote address. And this will be presented by Honorable Justice John Soho, Chief Judge, Federal High Court of Nigeria, who today will be ably represented by the respected Honorable Justice Akintayo Aluko. Please put your hands together as the Lord takes the podium. You're welcome, sir.
Thank you. The president and the members of the executives of BRIPAN, for the sake of time preservation, may I be allowed to stand on the existing protocol duly established. My job is to stand for my Lord, the Honorable the Chief Judge of Federal High Court. So I am told to deliver his keynote address. With humility and deference, we have the singular pleasure and honor of His Lordship, Honorable Justice John Tahemba Soko, the Honorable the Chief Judge of Federal High Court of Nigeria, to deliver this keynote address. The theme of the conference is Deepening Insolvency Tools for Resolving Commercial and Financial Challenges of Businesses. I bring good tidings from His Lordship, who sincerely appreciates and feels highly honored to have been invited by this august body, BRIPAN, as a distinguished keynote speaker at this conference. His Lordship would have loved to grace this occasion in person, but for his busy schedule and the already packed up engagements before his receipt of the invitation. Like I said, the job of his Lordship is to speak to the above referenced team of the conference. Principally, the essence of the conference is aimed at inviting discussions on strategies for restructuring and insolvency during this period of economic challenges. This will invite discussions and highlights on the roles of all stakeholders, namely the judiciary, regulatory bodies, and insolvency practitioners. No doubt, these stakeholders like the insolvency practitioners, regulatory bodies, and the judiciary have fundamental roles to play in the quest for structuring and insolvency and proceedings relating to same. The conference is expected to invite discussions on the the fundamental ethical principles and ethos required of insolvency practitioners as conventional codes and rules of practice for resolving commercial and financial challenges of businesses. These ethical rules may include observing integrity, independence, partiality, and transparency, acting in the best interest of beneficiaries and avoiding the practice of seeking personal gains from insolvency practitioners' fiduciary duty of care, observing good faith and honesty, avoiding conflict of interest while performing their duty, maintenance of confidentiality of sensitive corporate information. Insolvency practitioners must shun the practice of using confidential and sensitive information for personal benefits. The conference is expected to invite discussions on the limitations and challenges encountered by insolvency practitioners in the course of their practice and professional engagements. Areas to address may necessarily include a limitation and inadequacy in legal framework as the primary legislation governing corporate rescue and insolvency practices in Nigeria. The relevant provisions of the Companies and Other Matters Act 2020 should be looked into and addressed to drive or achieve an effective execution of corporate rescue plans. Limited corporate rescue mechanism. The importance of Nigeria's corporate rescue mechanism, namely administration, arrangement and compromise, receivership, merger and acquisitions cannot be overemphasized. However, it has been contended that there is need for an expansion of the scope to create more rescue mechanisms and the quest to simplify the existing methods. It has been stressed that there is need to have specific qualification and regulatory oversight for insolvency practitioners in Nigeria to prevent appointment of persons and individuals without the requisite expertise, experience, or accountability. Focus should be on discussion for introduction of a training course for prospective insolvency practitioners, necessity for post-appointment assessment of professional conduct of insolvency practitioners to enable practitioners to engage in effective rescue of companies under insolvency with competence. The above, we assist tremendously insolvency practitioners in achieving effective performance and attainment of best practices in adopting appropriate tools for resolving chronic indebtedness and insolvency complications. Suffice to state that the basic tools for resolving chronic indebtedness and insolvency complications may include receivership, administration, arrangement and compromise, merger and acquisition, bankruptcy, winding up. An insolvency practitioner will need to adopt any of the above tools in resolving issues relating to chronic indebtedness in the best interests of the creditor and the debtor companies. The role of an insolvency practitioner in the life of a company under insolvency is significant. It is to be noted that a state of insolvency does not necessarily signal the end of a business under insolvency. The insolvency practitioner includes its tool while observing the requisite codes of ethics. There are different kinds of insolvency options capable of revitalizing a company under insolvency or turning its corporate life and existence around. A voluntary arrangement or compromise, merger and acquisition, may be suitable for the purpose of restructuring the company and giving it a rebirth to productivity and profitability. An administration order may also be useful for the revival of an ailing company instead of winding up, which put an end to the life of the company. It has been emphasized that merger facilitates growth and development, while acquisitions facilitate expansion. Care we have to be taken to ensure that risk of resulting shrinkage in job opportunities and encouragement of monopolies should be looked into. The role of regulatory bodies under insolvency practice is also expected to be focused and addressed. As a primary regulator, the Corporate Affairs Commission should be further strengthened by legislation in the performance of its regulatory functions, where the interests of creditors are protected and at the same time debtors are allowed to breathe. The Commission must be encouraged and always to be alive to its duty and continue to play its significant role as a regulatory body by embracing technology and be more responsive in dealing with insolvency practitioners. Nigeria is widely believed and seen as a creditor-friendly jurisdiction, particularly with respect to special provisions in our legislations, particularly I refer to the AMCON Act. The provisions on special recovery procedure, custody and possession of debtors' property, attachment and freezing of debtors' bank accounts, bankruptcy proceedings, special powers in writing of proceeding, and appointment of the Asset Management Corporation of Nigeria as a receiver, or power to appoint one under sections 448 to 52 of the AMCON Act. And their relevance to insolvency parties and proceedings may have to also be addressed. The need to protect the interests of the borrower, the debtor who is proactive, sincere, and genuinely seeks and/or embarks on repayment obligation of its indebtedness should be a focus of discussion. This may bring to bear easy and seamless expansion of businesses, particularly in the times of economic challenges. More importantly, the role of BRIPAN is critical as a stakeholder in the insolvency practice. We all know that in order to qualify as an insolvency practitioner in Nigeria, a person must necessarily, among others, be a certified member of reputable, goal-driven professional bodies like BRIPAN or BRIPAN to ensure competence and adherence to well-established professional norms and ethics. The conference is expected to encourage or welcome discussions on the need to possibly widen the scope of BRIPAN's role in this direction. Continuous assessment of the practice and activities of an insolvency practitioner is a welcome development to achieving optimum performance as done by bodies like IBBI, which regulates and oversees insolvency practice in India, and IPA, an insolvency regulator in India. Insolvency and its tools may have been abused by lawyers and practitioners, and the judiciary has a duty to play its own part as an unbiased umpire. No doubt, the Federal High Court is conferred with exclusive jurisdiction over cases and matters relating to bankruptcy and insolvency. The Federal High Court clothed with regional jurisdiction on matters relating to insolvency and parties as a court of first instance. The court has been playing pivotal roles in checkmating cases and instances of abuse to which basic tools of insolvency, such as administration, receivership, petition, have been put. The court has been confronted with cases and instances where lawyers seek orders for the protection of a receiver manager, even when time for repayment of facilities are not due, and in the absence of any credible proof of default on the part of the borrowing party. There are instances when lawyers seek protective orders for a receiver manager before proper registration of instrument or deed of his appointment. Aside these few cases of anomalies and irregularities, lawyers as insolvency practitioners have demonstrated and recorded appreciable good practice and high sense of responsibility in handling insolvency matters. We have had cases and instances where the court intervened by granting order of injunction to prevent dissipation of secured assets and funds in banks which borrowers pledged as security for repayment of their loans. We have had cases where injunctive release were issued as temporary reprieve to stop directors and principal officers of companies that are already on red alert with early warning signs of insolvency from moving funds out of jurisdiction or out of the reach of the receiver manager. We have dealt with instances where the court must have to refuse applications for injunctive further orders deliberately made to frustrate creditors or their agents from realizing funds trapped in the custody of borrowers. As a court, we have had situations where we see the need to refuse an order of injunction seeking to restrain our receiver managers from performing their statutory duties. In cases where administration applications or where sections for arrangement and compromise, merger and acquisition are sought for, courts have had reasons to treat such instances as urgent situations necessary to rescue the companies from total demise by way of judicial intervention. Our stakeholders in matters relating to insolvency practice and proceedings, and in the adjudication process over such matters, insolvency practitioners, regulatory bodies, and the judiciary must play their own role in dealing with unsolving various troubling economic challenges faced in businesses. This year's conference is expected to be more engaging, exploratory, and rewarding. The Honorable Chief Judge of Federal High Court of Nigeria is delighted and welcomes all members of BRIPAN, stakeholders, and respected attendees, namely the finance experts, regulators, entrepreneurs, judicial officers, including attendees from other countries to this all-important conference. His Lordship wishes all a productive and purpose-driven conference. Thank you for your time, audience, and participation.
Distinguished ladies and gentlemen, may we rise in honor of my Lord? Please, may I request, before we move into the first session, we're just going to take a brief photo session to mark the close of this opening ceremony. May I request our keynote speakers to please step forward, joined by Mr. President and of course, Mr. Chairman. Please, this will photographers, where would you like to have them?
Thank you.
Okay. Please, may I request that you come on stage so that we can take a quick picture? Yes, sir. Upstage, because of the lights. May we have Mr. President? May we also have Mr. Co-Chair? Ladies and gentlemen, please feel free to scan the barcode so that you can get the brochure. Scan the barcode for the soft copy of the brochure. Photographers, are you okay like this? You need them to move in? Sirs, please, may you just move in so we centralize? This way, sir. Please, may we have one with everyone smiling? Let's reflect the happy state of our nation. Are you okay, photographer? Please put your hands together for them as they go back to their seats. Thank you so much. Thank you. And of course, you know that no building will stand without a foundation. We're not on a break, oh. May I humbly crave your indulgence? Please, may we be seated, ladies and gentlemen, my lords. May we please be seated. We will have time for networking, but please, may we be seated? The conference is still in session. Thank you. I was just about to say that no building can stand without a foundation. And the strength of a building is dependent on the strength of its foundation. Today, we are building BRIPAN on a very strong foundation, one that was laid by our past presidents. And of course, today, it would not be right for us not to recognize our past presidents who are here with us today. Distinguished ladies and gentlemen, please join me, put your hands together as we recognize Dr. Abiodun Leonu, who is here today, SAN, who is here today. Of course, we have Otumba Ayodele Akitunde, the very distinguished SAN here with us today. And we have Mr. Sheyi Akinwumi. Please put your hands together. Always a pleasure seeing you, sir. Would also like to recognize Dr. Adebola Olubanjo, FCA, FBR. Thank you so much, sir. I'd like to recognize Otumba Olusegun Fabumi, SAN. It is such a pleasure having you here today. And also the very beautiful, delectable Mrs. Folashade Ali, SAN, Chairman, NBA Section of Legal Practice. Great to have you here. Not forgetting, and also, indeed, having you here today is a pleasure. Ms. Toyi Bashir, SAN, such a pleasure, so beautiful. All right, distinguished ladies and gentlemen, we are about to take a deep dive. Stretch your hand, stretch your hand. We just closed out with the opening ceremony. We're about to take a deep dive. It's going to be 2 hours, 2 hours of deep conversations, 2 hours of, I don't know if I should call it nerve-wracking conversations, because the people we're going to be having will definitely not be sparing any stone. They would need turn all the stones, as we will be looking at deepening insolvency tools for resolving commercial and financial challenges of businesses, stakeholders' perspective. To help us with coordinating this session, we have 2 very beautiful, hardworking ladies. We have Chinyere G. Ugochukwu. Please put your hands together for her. Associate at Brief and Case Attorneys. And of course, we have Cynthia Abomma, Associate at Chikwem Chambers. Ladies and gentlemen, please put your hands together for them as I hand the microphone over to them.
Good morning, my lords, the chairman, distinguished ladies and gentlemen. You are all welcome to today's conference. We'll be standing on existing protocols and we'll proceed with today's session. My name is Chinyere Gift Ugochukwu from Brief and Case.
I'm Cynthia Mama from Chikwem Chambers, and we are the coordinator for this session. For session 1, the topic we'll be looking at is deepening insolvency tools for resolving commercial and financial challenges of businesses. We are going to be looking at the stakeholders' perspective. So the first speaker for today, permit me to welcome Mr. Orji Okpechi. I'm very sorry for the pronunciation, pardon me. Mr. Orji Okpechi. He's the managing partner and CEO of Grant Thornton. Nigeria with over 30 years of audit and assurance experience. He's a versatile professional and compliance specialist. So he has led major assignments across technology, media, and telecommunications, insurance, capital markets, petroleum, energy, manufacturing, pharmaceutical, and trading industry. You're welcome, sir. Can I have your seat?
Our second speaker is Mr. Sesu Famave. Mr. Sesu is a leading insolvency and restructuring expert. His practices covers cross-border asset recovery, corporate workouts, credit negotiations, and insolvency litigation. He is known for blending technical expertise with pragmatic strategies. Sesu focuses on energy, real estate, financial, and infrastructure sectors and contributes actively to advancing insolvency practices in Nigeria. You're welcome, Mr. Sesu Famafe.
The third speaker is Jote. Jote is a partner in the restructuring and insolvency practice group at Airline and Glady Limited Liability Partnership. She advises on cross-border restructuring and insolvency matters, including structured debts and trusts, and is recognized as a standout partner who is extremely competent and always willing to help. She'll be joining us virtually for this session. Jote is already logged in. Can you please confirm that she's already logged in? She'll be joining us virtually for this session. Thank you. You're welcome, Jote.
Our next speaker is Mr. Bidemi Daniel Olumide BD. Mr. Bidemi Daniel Olumide is the managing partner at Anaje Olumide OK Akinkugbe AO2 Law, and executive director of Global Recovery Limited, GRL. He leads AO2 Law's commercial and criminal law practices, where he deploys his expertise in financing, taxation, insolvency, trust, and criminal law. He is the group CEO of T Group Businesses, a conglomerate currently focused on professional services, technology, logistics, and energy. He is a fellow of the Chartered Institute of Taxation of Nigeria and associate of BRIPAN. BD advises and represents clients globally. For more information about our speakers, we will please kindly refer you to the brochure. For Mr. Oji Okwechi, you can check page 32 of the brochure. For Sesu Famafe, you can also check page 32 of the brochure. For Jote, you can check page 33 of the brochure. And for Mr. Bidemi, you can check page 33 of the brochure. I beg your pardon.
Chairing this session is our chairman, Dr. Abiodun Ishola Layono, SAN, FCR. He's an experienced insolvency practitioner. His work spans cross-border matters involving the United Kingdom, the United States of America, Spain, and is a founding member and a past president of BRIPAN. He's also a fellow of the Chartered Institute of Arbitrators and served in various governmental, corporate, and professional capacities. You are welcome, sir. You can find the complete profile of Dr. Layono on page 31 of the brochure. Thank you very much.
Please have a wonderful session. Thank you.
Mr. President, my lords, we spent very good time, nothing but we are slightly delayed. We have 2 hours for this session. Mr. President, I promise you we will not go over. We may be under, but I doubt it. But we will certainly keep within the 2 hours.
I'll go straight to work. Ladies and gentlemen, we believe, all of us here, we believe we know a lot. I want to say that we know everything, and that is good. However, there will always be opportunities to listen to speakers, experts, and gain another perspective, experiences, knowledge, and that makes us better. I believe that after this session, we will be better practitioners, we'll be better academics, we'll be better stakeholders in the insolvency practice. Summary of my opening statement. As chair, I have 15 minutes. However, I will not take that. I would rather donate the rest of my time to the speakers so that the audience gets to really learn in a very short time as much as possible, and to give some time for one or two questions. Now, here with this session, we all know that there's a need to have a system that promotes efficiency and orderliness in insolvency. There are stories of the past, even before BRIPAN itself was established, about the manners in which a lot of insolvency events have taken place. Sadly, there have been physical, sometimes very bad activities on a physical level of when the insolvency practitioners come. But I believe that since the establishment of this association, we will continue to have less and less of that. Of course, when the environment of the insolvency regime is a poorly regulated one, it leads to loss, financial loss in billions, and jobs, much more importantly, to loss of jobs. Because there are always serious commercial and financial challenges, when insolvency happens. And some of these challenges will come from various stakeholders, the creditors, the debtors, and so even the judiciary. We could have on the part of the debtors, for instance, a lack of sincerity and recalcitrance on the part of debtors. Then sometimes changing government policies, high interest rates, unfavorable business environment, failure of even banks. When that happens, a lot of pressure comes, even on borrowers who perhaps even have been performing relatively well. But when the pressure comes even on the creditor himself, like a bank, of course, the attitude is to come and even begin to see how they can begin to bring in all the credits. Now, we also have poor attitude of regulators, especially when it comes to the special areas of insolvency, bank failures, insurance failures. The most prominent one, no, I'm not labeling them, I'm just saying, of course, AMCA, with a special law and their special procedures. And at the end of the day, we all hope that our stakeholders, all in the system, will be able to increase our knowledge, experience, and the insolvency tools. I'm not going to, for details as to this session, if you go to page 21, from page 20, 21, you see all that is there. We're going to go straight away and take the first session, and that is Mr. Oji Opechi. The one sentence I really want you to really pay attention to, I find very interesting, is in his synopsis, the last sentence there, he said, this session will, from a very practical standpoint, examine how insolvency tools may be used for the purpose of enforcing an arbitral award. I am very keen to learn that. I'll take the notice as each speaker comes up. You have 20 minutes. You have flexibility as to how you're going to use that. You have already whispered to me that part of your presentation will include one of your colleagues coming up here. May I call upon him now, please, Mr. Let him know. Let him. I think we still have an extra chair. He can come up here for now. Keep yourself within time. Cynthia, where are you? Please, you are the timekeeper. I hope you'll be able to see me across. You know, we really must keep to time. Thank you very much. So, over to you, Mr. You may want to take your seat, or you may want to come over here. Thank you.
As the chairman, please. Okay. Permit me to sit down if you don't mind. Okay, thank you. The president of BRIPAN, the chairman of the session, fellow participants, keynote speakers, I say good morning. It's my pleasure to be here this morning to contribute to the success of this year's conference. But before I proceed, permit me to invite my boss, who came all the way from UK, to support us in this program. I'm calling Mr. Amechin Sofo. He has been a past presenter in these conferences. Amechi, please come over. Yeah. He is in charge of cross-border insolvency practice in Grand Thornton, UK. And he oversees Africa and Europe and Middle East operations, largely Africa. And this presentation will not be complete if we don't look at cross-border aspect of insolvency practice. I'm privileged to have him here, and I want to make sure that we utilize this opportunity. Thank you. Again, my name is Oji Obechi. I'm a chartered accountant by profession. I'm a certified forensic accountant. I'm a fellow of the Chartered Institute of Taxation and a tax practitioner. I'm an insolvency practitioner, and also I am an European Mentoring and Coaching Council accredited coach. I'm in public practice. I'm presently serving as the Managing Partner's Chief Executive Officer of Grand Thornton, Nigeria. I want to thank the organizers of this conference for giving me the opportunity to be here and to appreciate the presence of the personalities in this conference to equally lend me their listening ear. I don't think anybody is presenting my slide. Okay, I'll be talking because I was thinking that my slide would have been presented. Good enough, I have something. So I'll be talking from my table of content, the way I've arranged my slides, which is with the organizing committee. Introduction, the legal framework for arbitration in Nigeria, challenges with enforcement of arbitral awards, insolvency tools under CAMA 2020, the strategic advantages of insolvency tools as an enforcement mechanism for arbitral awards. Then I will conclude. While concluding, there will be interactive session, question and answer. And that is where I want Amechi to come in. At least I have 5 questions there for him. If he were able to take to that, will be good. There has been growing dissatisfaction with conventional litigation process, which is often slow and frustrating. These challenges and dissatisfaction have a new regime where more people have turned to arbitration as an alternative dispute resolution. Arbitration is an alternative dispute resolution mechanism in which disputing parties, instead of resorting to traditional court system, agree to appoint a neutral third party or an arbitrator or arbitral tribunal to their dispute and render a final and binding decision known as arbitral award. And this is led by Arbitration and Mediation Act 2023. I know that there's a professional body on arbitration, and some of us here are in that body. Sorry. Some of us here are in that body. We understand what I'm trying to say there. So the key issue in this presentation or discussion is, even with acceptance of arbitration as a faster and a more efficient alternative to litigation, time has exposed that enforcement of an arbitration award can also be plagued with the same challenges which made people run away from litigation. What made people run away? It is delays and the slow enforcement processes. My view, that is my view, is that the insolvency tools under CAMA 2020 can be applied to more effectively enforce arbitration awards, which avoiding the challenges experienced with the traditional enforcement route. I know that the slides will be given to you. Here I talked about the legal processes of supporting arbitration, and it extended to state laws. Lagos has one and Port Harcourt has another one. And there is international aspect of it known as UNCITRAL, that is United Nations Commission on International Trade Law, and referred as soft model law. And good enough for us during the review and signing of CAMA 2020 into law, the CAMA took substantially part of this. So it is substantially applicable in our practice today. Key provisions on the arbitral awards in Nigeria. An arbitral award is the final decision rendered by an arbitrator or panel of arbitrators. It must be in writing and signed by the arbitrator or arbitrators. The award is final and cannot be set aside except on some grounds. And these grounds are defined in the Arbitration Act, such as the arbitration agreement is not valid under the law. 2, lack of proper notice of arbitration. The decision has exceeded the scope of the arbitration. The arbitral tribunal was not properly composed. The award was against public policy. These are circumstances under which arbitration award can be challenged. And when it is challenged, it takes us back to where we started or where we were about starting. That is litigation being the option. And we've talked about the challenges in going through the court to get judgment debt vis-a-vis collecting the debt, because you can get judgment and payment becomes another factor. I've been opportune to see this in different places where the debtor, the creditor will be unable to collect his money or sell off the assets or in possession of the assets. And eventually there will be appeal or ex parte order stopping them from doing that. And finally they settle out of court by exchange of blows. These people have their own policemen to lead them to come and take possession. The other one is defending himself with another set of police. Then the policemen will now down their guns and allow them to roughen it out. After that, the court. So challenges with the enforcement of arbitral awards, judicial intervention and delays. I have this in my slides 11 to 12. I was detailed there. Then heavy burden of asset tracing. Amechi will talk more about this asset tracing. It's a very difficult thing because from the time the company becomes sick, people are eyeing the assets and they are dissipating the assets and converting them and doctoring so many things there, including title documents. It's an experience we don't pray you have in practice, because when it's converted, you find it difficult to really trace them. Rest to the assets by competing creditors. Yes, as creditors are in the process of getting paid, they are equally looking at the takeaways, the assets they are going to take and the one that will be beneficial to them. Show a slow enforcement process anyway. The debtor will not just allow you to come in and take possession of his assets because he's owing you, even though there is an arbitration award. There will be resistance. Abusive challenges to awards by award debtors. That is another aspect of it. Even it I've seen in practice, forget about the proceedings and the law, where somebody has gotten it on, coming to take possession, came to the office the next day, he's reporting to the office, he saw a lizard with white cloth sitting on his chair. The man decided that he will never swear that place again. Let them permit him to carry his file and go, and that was the end of the matter. Then we look at the insolvency tools with which we can enforce this arbitration award. We have the company forensic arrangement. This is what we know. It's very large. Begin to analyze it, the options we have here. We have a scheme of arrangement. It's just what the creditor and debtor has agreed on the way forward. And it has to do with debt rescheduling, how to make it possible for the creditor to get his money even over time, and for the debtor to continue in business as a going concern. Where it fails, there are other options. At times the problem might be the directors of the company. What do you do? Some of them will package themselves over trips and live flamboyant lives at the expense of the company, and the company is dying, they're not paying creditors and servicing the stakeholders. So in that case, an administrator might be appointed, and the administrator will ensure that the business is turned around, having noticed the loopholes in the system and what caused the financial, distress. And in most times, it is the floating charge creditors that appoint this administrator, or the company can decide to do it. But what is important is that the administrator is able to manage the resources well, and they return the company from insolvent position to solvency. So when administrator is involved, three things are normally there to look at: rescuing the company, the whole or part of the other as a going concern. B, achieving a better result for the company's creditors, and as a whole would be likely if the company were wound up without first being in administration. 3, realizing property in order to make distribution to one or more secured or preferential creditors. So in this case, the next thing we can exercise is liquidation, but liquidation comes as a final result when rescue has failed, administration has failed, and so on, and the schemes of, CVA have equally failed. In CVA, there are so many options, including acquisition, merger, um, uh, um, that is arrangement and compromise, workout, and so on. It means restructuring, agreeing to shift base, forgo some of your rights and obligations, and a little to the left, a little to the right. Then you come to a compromise which is acceptable for everybody. Having said this, what are the advantages of this? It is uncovering of hidden assets and the clawback of fraudulent transfers. It shifts the burden of action in discovering assets. Insolvency proceedings create a collective process where all creditors' claims are consolidated. They equally provide significant leverage for the creditors, as the debtors fear loss of control, damage reputation, and potential dissolution. Insolvency proceedings oft opens the potential for debt restructuring. My conclusion: while arbitration provides a swift and flexible mechanism for dispute resolution, the true test of its effectiveness lies in their enforcement. The resulting appalls. In Nigeria, as with many jurisdictions, creditors face significant challenge in an arbitral award into a tangible result. The traditional litigation first route, enforcement routes, which involve a series of court applications and asset tracing efforts, are often slow, cumbersome, and ultimately insolvency proceedings are not resort. They involve spurious strategy for creditors by leveraging the comprehensive powers vested in an independent liquidator on various companies and other matters Act 2020. Creditors can the limitations of traditional investment. So, for the benefit of having the international practice benefit of this presentation, 5 questions, but I would like Mechi to take on question number 3 and question number 4, if time permits. Yeah. The 3 is giving your, Amechi, this question is for you. Given your cross-border experience, how do differences between jurisdictions, for example, recognition of foreign insolvency proceedings under the ancestral model law or otherwise, impart the ability to use insolvency as a strategy for enforcement?
No, thank you very much, Oji. Just in the interest of time, I will just dive into the headlines, and then maybe during the break we can network a bit more and do a deeper dive into the answers. So, as a caveat, I am not a lawyer. I am outnumbered here by a lot of legal luminaries and legal minds. So what I wanted to say about arbitration is when it comes to debt recovery, asset recovery, getting the money back on behalf of the creditors, we need to question whether or not arbitration is an effective mechanism to do so. I used to hold the view that you cannot arbitrate your way out of a debt recovery matter. You litigate your way out of it, and then you enforce whatever award you've got out of the litigation. And this is particularly important when it comes to cross-border matters, because the enforcement of cross-border awards across different jurisdictions is the main impediment that we face when we're trying to get the money back on behalf of creditors. So that's what I wanted to say. UNCITRAL is very helpful, but as far as I'm aware, Nigeria has not yet signed up to the UNCITRAL model law. So that makes it very difficult to enforce cross-border matters without entering into parallel proceedings on the ground in Nigeria. So I just wanted to stop there for the benefits of time.
Just 1 minute, sorry.
Okay, thank you. Asset tracing is often critical when debtors receive payment of arbitration. Could you explain how insolvency processes help uncover hidden assets and how Grant Thornton leverages forensic tools to support cross-border recoveries?
Yeah, I mean, the starting points for any debt recovery matter has to be with asset tracing. If you don't have assets, if you don't have collateral, then there's no point in wasting your time pursuing legal enforcement or processes against a debtor. At Thornton, we have our own in-house corporate intelligence team. We have data analytic tools that we deploy to find out where these assets are. And then as a further stage, we also deploy human intelligence, which effectively is people going around looking in dustbins and things like that to find out evidence for us as to where these assets are hidden. So what I would say is that is a mixture of human intelligence and data driven tools that we deploy in asset tracing to find out where those assets are and recover the assets on behalf of creditors.
Thank you, Amechi. My chairman, thank you very much for doing that.
Thank you very much. Please we commend and applaud Mr. Oji and Amici for their contribution. For me, the one line I would hope that at a better opportunity will come to be able to explore this further is that, as we all know, arbitration is more or less private litigation. For me, the major benefit or advantage of arbitration is about the privacy and the confidentiality it offers. In recent times, all the traditional benefits have become debatable in terms of cost. For instance, sometimes arbitration turns out to be a lot more expensive than even using the, because in arbitration, you are paying everybody. You are paying your judge, unlike in the litigation where the judicial officers are paid by government. You are paying your judge. You are paying the registrar. You are paying for the venue. You are paying for, the parties are paying for virtually everything. However, that advantage of confidentiality and privacy, I think, is what essentially drives a lot of. Thank you very much. That's the first paper. Sophia, I will pay for time. Okay. So I come from Miss Sesu. I like to get things right. Famabe. For those who are wondering, it's a Nigerian name. It's from Benue, right? So don't think that it's a foreigner. It's not a foreigner. Seso Famabe. Being a legal practitioner. Yes. It will take us on the next paper. Deepening insolvency tools, the practitioner's insight. The thing that I believe we're all looking forward to is we know that virtually all of us here know the insolvency tools, but how you now show us that from a practitioner's perspective, the ways to consider ways of boosting the efficiency and effectiveness of these insolvency tools. Thank you. I think I will take this seat. Are you comfortable? Do you have a slide? Well, those of us who are old school still prefer our paper. So please go ahead.
Right. Good afternoon, everyone. On the existing protocol, my name is Sisu Famavi. I'm a proper Nigerian. I'm from Benue State. It's a pleasure meeting every one of you here. Thank you. Yeah, it's a privilege to talk on the topic deepening insolvency tools for resolving commercial and financial challenges of business, the practitioner's insight. So when I was informed that I was going to talk about this topic, I was looking at how am I going to make this topic very practicable. It's beyond, just citing the provisions of the law, is what are the practical steps we need to take as practitioners to ensure that we make use of these insolvency tools. And first of all, just to understand the why we are gathered here. Because I always tell people that when you don't understand the why of a thing, abuse is something that you cannot avoid. So it's very important as practitioners to understand why there is need for us to deepen these tools for efficiency. We all know that there are provisions as contained in Company and Allied Matters Act for receivership, for liquidation and what have you, and the new insolvency tools, which are administration, and of course, CVAs, amongst others. Now, we know that it is very important for us to understand that as practitioners, if you are approached for an advice, or maybe for instance, you are appointed as an administrator of a company, what are those things you need to do? It's beyond just you going into a company to take over the company, right? It's beyond that. First of all, what you need to do is, I'm talking whatever I might be saying is out of practical experiences I've had over time. Okay, we might not really see them in books. Okay, right. So the first thing you need to do as an administrator is to call for a meeting. That's called a meeting for among all the managerial, the officials of the company at the managerial team. And there are certain things, because from experience, people just take over companies and, in trying to prepare, report and what have you, you discover that there are documents you cannot even, come across or find. So it's very important to have a meeting with them as sacred as is the element of the law. So when you have this meeting, make sure there are set documents that should have acts of these documents, one of it should be the list of the assets of the company, list of creditors, you know, the financial standing of the company, that's financial statement of the company, and among other documents, right? Now, when you do this, one of the things you need to do is, you need to ask yourself as a practitioner, right? I'm using an administration as an example. We have other insolvency tools, right? So one of the things you should ask yourself is, why is it that this company is unable to pay its debts? Could it be that it's as a result of bad management? Could it be that maybe it's as a result of lack of cash flow? Could it be that they are overstaffed? You know, these are the salient questions as a practitioner you should ask. And it is only when you are able to answer these questions. Maybe, for instance, if you see that maybe the problem is as a result of management, you can overhaul the entire management. If you discover that maybe at the managerial level, they don't have, you know, people who have that much expertise, you can bring in partners to help them. Am I making sense at all? Good. Now, you look at their staffing, because of experience, we discover that there are companies, when you take over, you discover that they give out so much loans to their staff, and you don't see evidence of them paying back these loans. It's one of the things, and you see, at times it's little fogs that spoil the vine. So when you discover that maybe it's as a result of maybe overstaffing, maybe, for instance, there are 20, and you know, maybe one is earning 20 million, one is earning 5 million, 2 million, 2 million, as the case may be. You look at it, if 30 of their staff can be able to deliver on the job, it's better to cut down the staff and calculate the money for those 20 staff. Maybe, for instance, they're earning 1 million. Calculate what you get by the end of the month and by the end of the year. You are saving, and it will help the company. When you look at all these options and you discover that, okay, there is all this option is not really the problem why the company is unable to pay its debts, you can inject more capital into the company. You understand? Inject more company by calling more partners to invest into the company. You know, one of the things why I talk with this passion when it comes to restructuring is because I can imagine why a company has been in existence for over years. And maybe because as a result of cash flow or something, you know, a creditor can just, because creditors have this aggressive means of recovery, of going to court. We just put a company into administration or even file a liquidation proceeding against the company for that company to go into extinction. I know currently ShopRite, they are experiencing some form of restructuring. So there are better ways. The gospel I'm trying to preach, or I've been laboring to say here, is that there are better ways you can, go about, implementing this, to not necessarily resolving to, taking companies to the court. Because another thing is that for big companies, when you take them to court, you discover that one of the effects it has on those companies is what I call reputational consequence. It has a way of affecting their business. It has a way of showing a bad image to the public. So there are better ways to go about this. And as practitioners, you need to understand how to deploy these tools. They are very, very important. And you need to understand how you deploy them, not just rushing to, advising that maybe a company be put into, liquidation. That's the aim, is going to extinction and what have you. And to business owners that are here, I want to tell you that as restructuring experts, we are no enemies, because you discover that as an administrator, for instance, when you take over companies, the company owners see you as an enemy. They don't see you as a friend. We're all only coming into your company to restructure your company, to help you. And you see, a typical example of insolvency in Nigeria is like that average Nigerian, who doesn't go for tests, who doesn't go for medical tests until he discovers that, his health has gone so low to the extent that he cannot help itself again. That's a typical example of insolvency in Nigeria. And what we are saying is, it is no crime for you to cry early. Seek for advice early is very important, right? So these are the practical things that you need to do as an insolvency practitioner. I know I'm talking from the perspective of a lawyer. I'm even very happy that we have a body called BRIPAN, because one of the things, again, we see in practice is the issue of experience. For the fact that you are a lawyer does not, sorry to my colleagues, does not mean you should, people are carried away by, having the title, I am an insolvency expert. See, as an insolvency expert, you don't just need the knowledge of the law. Am I communicating at all? You don't need the knowledge of the law alone. You need knowledge on management. You need knowledge on negotiation. You need knowledge on finance. These are the things that will help you. Because if you are not a good manager, how are you going to take the affairs of a company and manage it very well if you don't have a good knowledge of management? And you must have a proper knowledge of negotiation. I keep telling people, lawyers especially, who are insolvency practitioners, that, see, insolvency, right? Restructuring is 10% litigation and 90% negotiation. So you must master the art of negotiation. I tell you the truth. So it is not just enough for you to say that you are an expert in this area. Well, of course, but you need to understand dynamics so that when you are confronted, or when you're somebody sick, you know which of the option or which of the right counsel you are going to give. Of course, we are not saying that the old traditional, insolvency tools are not important. They are. There are instances we all know, as I was. Okay, 5 minutes. All right, I'll try to wrap. We are not saying that the old insolvency tools, liquidation, they are not important. They are, of course. But what we are saying is we should be rescue sensitive. Because when you look at UK, you look at United States of America, they are more rescue sensitive. So what do I mean by that? They look at killing off a company, which is liquidation, as the last resort. So I also look at it as the issue of implementation, and of the stakeholders. Because I'm not as a legal practitioner who is an insolvency, expert. It behoves on me to give you the right counsel. It behoves on me to be transparent in my dealings. Hello? So, if these insolvency tools are rightly implemented, we will not have, of course, there might be issues, but I think we might not have issues as the way it is. And again, I see, in practice is, of course, we have, proof on even having an insolvency unit, but I was shocked, when I went to Federal High Court and I was trying to know whether we have an insolvency, unit here in Lagos, and I don't know, that was like a month ago. I was told we are yet to have it here. It's only in Abuja. And I was like, why? Because when you look at Nigeria, us is highly commercialized. You know, all these highly commercialized areas like Lagos, of course, Port Harcourt, and of course Abuja, because Kano, have been there. You know, we need to have these units there for efficiency. So that calls for, I know, you know, business owners usually see us as we are coming to take over the ownership of your company. You need help, and we are coming to help you, right? That's all we are doing. Most of the times, what we see in practice is business owners usually see us as enemies. We are coming to take over the ownership of their company. No, you need help, and that is why we are coming to do that. I want to read, my time is almost, I want to read my last conclusion. There's something I want say. Okay, all right, thank you. Yeah. Okay, thank you so much. Yeah, this sounds better. Thank you, sir. Right, so business rescue is not about avoiding failure. It is about preserving value and giving enterprises a second chance. And as insolvency practitioners, we must rise as architects of recovery, bridging law, finance, and comments, and to ensure insolvency is not an obituary, but a strategy for continuity, resilience, and growth in Africa. Thank you.
Thank you very much, Cecil Famavi. We're in good time. I hope that Jote, who is taking the next paper, she's speaking from Singapore. We are looking at up to 11:30, if I get it right. And after the next two speakers, if they're taking their 20 minutes each, I hope we have some time to take some question and answer. While we are waiting for Jote from Singapore, the first paper, oh, she's there. Are you ready? Please, we can hear you very well. So I'll hand over to you in 30 seconds. She's going to be telling us about the Singaporean experience. And the theme at the end of the year, what you should be able to take away will be this session will draw lessons from Nigeria and from the Singaporean journey and experience. Welcome, Jote.
design and form um 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 recently in 2018 when admin 17 we introduced a trade that was increased. Just to protect themselves.
And I commend you for that. Ladies and gentlemen, I know this is not court, but please, can we extend a little bit more courtesy to the speakers? And what I mean by that is, let us appreciate the effort, the in preparation. If they come here, it's just 20 minutes. The entire session is just 2 hours. Please, I really appreciate it if we can be a bit more quiet and take it. Before you know it, 20 minutes is all up. I mean, we've done virtually 3 now. There is one more left. I had noticed that, but I really had to say it on, because they compare, or what I said, the lady came to me and actually passed me a note. Thank you very much. I appreciate this. We are going to have some, before I call on Mr. Olumide, that's the surname, Mr. Peter Olumide. We are going to, the way it's structured, we are going to have some time, I assure you, in having some question and answer. I won't take too many. I would, as chairman, have discretion. But I'll just say that whoever is going to be asking questions, please be very brief. Go straight to the point. All of us here have some modicum of knowledge and experience in the field. You will not need too much background, before you go to your, so that we can really, really enjoy the session. I think before we get to that stage as well, we've had a Singapore experience. Even myself, I have 1 or 2 things. I'll just say to the president, the one thing I want to take away from here, I don't know, the younger ones here should know, do we have this idea of moratorium in Nigeria? And how can we make that very effective? These are some of the questions I would expect to come, from the audience. Then also, I think from experience generally, the real problem of insolvency and why we have so much resistance in Nigeria is because it's like a death sentence. The moment the creditor takes steps towards recovery, and let's say the one that's most devastating, of course, is when a receiver manager is appointed. Automatically, a lot of people doing business with that company will panic. They want to stake shares, they won't come again. If, for instance, suppliers, maybe who have been giving credit, to that company, and they now know that a major creditor or registered creditor is already in and pursuing the company. If they've been given 90 days, 45 days, they will stop. Then you find out that in the special areas, for instance, with banks, the moment you smell any idea or aroma that a financial institution is under any form of distress, the only thing you are going to have left will be the debtors to that bank. Those who have money will begin to move their money away. So I wish that sometimes it should be a theme of a future conference. How much can we, to what extent can we have some quiet proceedings in insolvency matters? Would this help generally in the business? Recently I have an experience of a matter I'm doing where the receiver manager was so cooperative that all the traditional steps of the publicity, the whatever, he did not. We sat down, we spoke, we negotiated. He embedded people, professionals, business administrators. He embedded one or two in the company such that those who patronized that company, they did not know that anything like that was actually going on. The company was still able to do it, and he was able to tidy up some of the areas, as Mr. Famabi was saying, that sitting down, talking to them, looking at the areas where things could be done better, maybe a reduction of staff, and the like. And within about 6 months, things got better. But it was because the company owners, the debtor actually cooperated. Without that cooperation, the typical thing is to challenge. You go to court. In the processes, court hearings are never private, except at the time you are getting maybe an ex parte order or something, or maybe cases of children and all that. Otherwise, what's filtered out. So we have that. Mr. Olumide will be taking the last paper, and he's talking about the effective use of ADR, alternative dispute resolution, in insolvency and restructuring. He would examine the most efficient ways of utilizing these ADR tools, as well as their practical benefits to stakeholders. Mr. Olumide, thank you.
There was
Yeah. Is this the best microphone?
it's okay. I'll go with this.
Okay, please.
Yes. Good afternoon, everyone. I promise to give you about 5 more minutes. Give you 5 minutes of my time. Oh no, I said I promise to give you 5 minutes of my time. So it's essentially to give that to the audience. I adhere to existing protocols. Milords, President Leonard Silks, Mr. President, Chair of the conference. I'm here to speak on the efficient use of ADR in insolvency and restructuring. Presentation has been prepared and a seminar paper as well. that will be shared by my team here present. Thank you so much for your very hard work on that. But in addressing the topic, I would rather like to tell, or I'd rather like to divide it into two parts. One is what I call the form of ADR, and the second I'll call ADR in practice. And to talk on those two, I would like to tell stories. In actual fact, I want to tell two stories. So let's go first to the form of ADR. So the year was 2017, January to be precise. I and two gentlemen sat together. I was transitioning at that time from a law firm known as Denton Sakers to form a new law firm known as Anaje Olumide Oke at that point in time. It's now Anaje Olumide Oke Akinkugbe. And one thing was very clear at that formation stage. Perhaps it was born out of our pride. We said we wanted a law firm proper. And I need to prefix that statement with due respect to other law firms and lawyers here present. We said we just wanted to practice law. And whatever other appendages there are to law, we would set up in different structures. We didn't want to dilute how we perceived. Mark you, I said perhaps it was born out of pride because we wanted, anytime our letters go out, we wanted to be taken a little bit more seriously. And so, we gave to about 3 different appendages that kind of surrounds the law firm. The large part of that practice as it relates to insolvency and debt recovery, we housed in a structure today known as GRL. GRL stands for Global Recovery Limited. And so really what I'm about to discuss is a story really of GRL. Because what we found out is that with GRL, we really are able to achieve much more in insolvency, debt restructuring, and 2 other practices. Why? Number one rule, whoever remember the phrase, right? If you want to make any progress, first what? Kill the lawyers. Yeah, inclusive of myself. So one of the first things we did in setting up GRL was that we really didn't want to give it a legal face. And it was important for the market. So one, we made it deliberate that we weren't hiring lawyers. And why is that? We felt that at certain levels of conversation, right, perhaps also because of our pride, we felt it was a little bit beneath us. We felt that there were professionals, perhaps, who could deal with that level of conversations and perhaps would not bring the convolutions that we could bring in as lawyers, because we are trained in a particular way. We're trained largely to be adversarial. We're trained perhaps to think of things black and white, perhaps why we wear that for our classrooms then. So we wanted to take the benefit of other perspectives. We wanted to take the benefit of those who are sat in intense workouts solutions. We wanted to take the benefit of accountants. We wanted to take the benefit of the insights of economists, administrators. So we designed it that GRL would largely, right, be populated by those kind of persons. To make you laugh, we wanted to take the benefit of those who could do the grunt work of actually, let me give you an instance, something like asset tracing. Yet today, there's a lot of technologies that perhaps GRL is integrated with that gives us insight into the credit histories of debtors, gives us insights into perhaps all we need to see in terms of the financial information of those who we're proceeding against. But sometimes also, it could be as simple as checking people out through social media. I don't want to do that as a lawyer. So the guys in GRL, yeah, those are the kind of things they do. They check you out, profile you, they get a good understanding of what the situation is, try to do all the investigations into the story, all right? If they need to engage, they engage with you, they sit down with you, draw out intense workout programs, facilitate all of that workout program, and when all else fails, we stay at the background as the lawyers and then do what we know how to do best. We don't give you a letter to threaten you. We give you our letters because we want to act. All preparatory work has been done. And I tell you that it's proven very effective. This is about 8 years down the line. The banks find it a bit an interesting model because they will also tell you they don't really want the letters of a lawyer because they say sometimes non-debt recovery, non-legal debt recovery facilitates the conversations a little bit better. I like to always use this analogy. To us lawyers, we are hammers. So everything perhaps sometimes looks like a nail. And there are sometimes we really don't want to hammer anything. We really just want to talk. And oftentimes this they find it a little bit much more convenient to speak to non-lawyers because when we come into the room, we are assassins. We go for the kill. Am I? So that's one, the first side of the story, the form of ADR. Perhaps we need to cloak ADR in another form. And I throw it as a challenge to those who perhaps want to look at that model, that it's a model perhaps that might work around uh, uh, debt restructuring, insolvency, debt recovery, and the likes. And we're very happy to share our experiences in the last 7 years of running the GRL structure. The second side of the story is ADR in practice. And I can dare tell you that I really can't teach you that because at the end, or I can't tell you much about that because that you find in your everyday practice. Yes, we've done some beautiful work to tell you about arbitration, mediation, negotiation, neutral evaluation. Let me say, a lot of that sounds very academic, all right? And I don't think in practice, how you move and how you swing is largely determined, right, by the situation and by what you're faced with. We were lucky, by God's grace, to have handled the very first administration in this country. That was the administration of Morehouse. We represented ACO, all right? And I can assure you that all what we did there was to have an admixture of almost everything, from a court to sitting down and all of that. Today, we are also handling another administration all the way in Enugu. And I can tell you, sorry, in Imo is an entirely different kettle of fish. I'm very sure that by the time you read what we've written, you'll certainly get some much more insights. Thank you very much, everyone.
Thank you. Yes. Promise made and a promise kept. Although the organizers, we are virtually at the end of the food for thought. Now I can see evidence of food for the tummy. That's already started. Yes, couple of questions. We have some time. Let me Because Jote is abroad, not here, there is a question here for Joe. Are you there? Do we still have Joe? Well, whatever the case, I'll take out the question and maybe she will get to know, or a message will be sent to her. And then, okay, you're still there. There's a question for you. It says, does the Insolvency Act of 2018 of Singapore cover all companies, including specialized entities or companies such as banks and financial institutions? Did you get the question?
Can I-
Please.
Okay. Jen, but you can wind up under the Insolvency Act, right? Singapore incorporated companies, for companies that have a substantial connection to Singapore, then it will be for the foreign company to come to the Singapore court and prove to the Singapore court that they have a substantial connection. For example, they have assets in Singapore, they have business in Singapore, they have shares listed on the Singapore Stock Exchange, and that's actually very common. Shares or bonds. It's very common for Indonesian companies to have that. And so when a foreign company can be wound up in Singapore, they can also use the schemes of arrangement and the judicial management regime in Singapore, which means an Indonesian company can actually come to Singapore, say that I have a substantial connection to Singapore because my bonds are listed here, which is common, and say, I want to use your regime to restructure my debt, for example, with your Singapore investors. And I want a moratorium to protect me. And that moratorium, actually, I didn't say earlier, but it can be worldwide. If you convince the court to give you the worldwide protection. And it's supposed to be a powerful moratorium that we see. Now, so those are the big categories of companies that can use the Insolvency Restructuring Distribution Act. For banks, insurance companies, financial institutions, those are carved out. They cannot use the general regime because there is a public interest, if you think about it, in the regulator, the Monetary Authority of Singapore, overseeing the restructuring of these special entities like banks. They have a very big impact on the people of Singapore. So there is no way we will allow them to go through a normal restructuring under the Insolvency Act. So that's the long answer to the question is yes, general companies and even foreign companies that have substantial connection to Singapore, but no to specialized companies like banks, insurance companies, and financial institutions.
Thank you. Thank you, Joe. I have a question. The moratorium you mentioned, is it automatic? Is it a matter of law, or there is any form of discretion in the court in granting it? The initial one of 1 month, of 30 days.
It's available statutorily under the Act. The first 1 month is free. It is automatic. It arises the moment you file the papers for a moratorium. So the court has to hear the application within 1 month to decide if you can have the moratorium for a longer period.
So,
and yes, the court has discretion and what has to say, do we are really planning to have a compromise on engagement with creditors, or are you abusing the system? Now, if they are abusing the system, then no further moratorium. If there's evidence and they are trying to put together a plan and creditor, then yes, you can have a further moratorium to give you more time to hold out legal plan.
okay, and finally for you, still on this moratorium, is there any form of protection, statutory protection for a creditor whereby in those 30 days, you do not have the debtor dissipating assets. That is abusing that 30-day period to quickly move some things around.
For sure, there needs to be protection for the creditors. In my, I use the actual creditor, so I'm always watching out for such action. And I'm very, I pay a lot of attention to what protections there are for creditors. Now, while the company has the 30-day moratorium, anytime in between, the options for the creditor are to ask for an urgent hearing to lift the moratorium and say that they are abusing the system, don't give them any more moratorium. That's one, right? Two, there is a separate application that the creditor can make to say that if you want to give the company a moratorium, there needs to be a separate order that the court makes to say that the company cannot dispose any substantive asset during this period. And for the period of the moratorium, if the court wants to grant it, actually the court must make other orders for the company to give financial disclosures on a monthly basis. And if it makes substantive disposals of assets, it needs to disclose this to the court. So there is a lot of oversight during this entire period by the court and the creditors, so that the company cannot abuse the moratorium protection.
Thank you very much. The reason why I went into all that is perhaps maybe Nigeria needs sometimes to deviate from a traditional approach of going to the UK. I mean, it's understandable being the sort of influence and colonialism and all that. Perhaps we should begin to look at other regimes and see what we can borrow, from them that would enhance our practice. Thank you so much, Jote. I see Mr. Folorenshaw was nodding when I asked a question. Do we have that? Can anybody please take that question? Do we have that presently or anything like that? It might not be called moratorium, but do we have anything like that currently in our regime? Well, we are within time. Yeah, we are within time. Anyone? Anyway, Mr. Yes, please. Oh, please give him the microphone. Briefly and straight to the point.
Okay, we don't
these sections, please.
We don't have moratorium regime in our law as of now. I was nodding because that same provision that she was speaking to was a provision in the UK that came in 2020 under the MOU. So they are copying from UK more or less. Thank you.
Thank you for that.
Lawal Michael is my name. I intend to disagree with his position. There are provisions in CAMA that provides for moratorium, particularly for appointment of administrator. It's for 1 year. Within that period of 1 year, you cannot enforce a court order against the administrator. It's clearly stated in CAMA under the provisions for appointment of administrator, section 7 something. And
okay, so once you're saying once an administrator is appointed, then
there is moratorium,
protection for the company, like chapter 11 or whatever, or
I may not be able to quote the exact section, but yes, from section 700 and something in CAMA that makes copious provisions for appointment of administrator. There is a particular section there where there is provision for moratorium. Very clear position of the law.
Okay. A follow-up question. Would you then equate the appointment of an administrator? Is it similar, different or same as appointment of a receiver manager?
The provisions under CAMA, I think section 560 something on appointment of receiver is clearly different from appointment of administrator. Hitherto, before CAMA 2020, the existing legal regime provides for appointment of receiver, but the appointment of administrator is one of the innovations introduced by CAMA 2020, and that provision, the main aim of the administrator, as we all know, is to rescue the company from going down. And once an administrator is appointed, there is a moratorium exists for a period of 1 year. It's for 1 year, within which legal action cannot be enforced against the company. But there is no such provision under appointment of a receiver, because the role of the receiver is clearly different from that of the administrator.
Can I just jump in just really quickly over here? Just one of the key differences between an administration and a receiver is that the administrator or the administration process is what's known as a collective insolvency process. Collective, that it looks after the interests of all the creditors. Now, when it comes to a receivership, you are acting on behalf of the creditor that appointed you. So it's not collective. That's very important when it comes to cross-border recognition, because only collective processes are capable of being recognized cross-border. So you have to be very careful when you're going for administration versus receivership.
Thank you. Any questions from the audience? Well, Mr. President, I heard you, Mr. President, I heard you doing your keynote, your speech. You mentioned that there is serious of progress on the insolvency rules. Did I get you right? So, are we going to have a situation where those rules will sort of a little bit of deviation from moratorium, but more of maybe some, should I call it privacy? Okay, because as I said, the main danger of when an insolvency regime or event happens, the moment either customers, those who use the services, or the moment they hear that there is problem, everybody runs away. And that alone can actually kill the business and reduce the chances of any recovery or restructuring. Can we develop some sort of regime to cater for that?
Thank you very much, the chair. Well, the truth about it is that within the legal work, we have adequate options, like Amechi has pointed out. But is to understand under what circumstances you can employ each or any of these options. And that is the main thrust of this whole conversation at this conference. In terms of receivership, within the Nigerian law or under the Nigerian law, you have situations where an insolvency practitioner can be appointed as a receiver. In other words, he's not entitled to manage the business. He will just realize the assets. There are other instances where you can be appointed as receiver and manager, but you can elect to only act as a receiver or to act as a receiver manager, because the obligations are different. If you choose to act as receiver manager, you must, within that assignment, also retain both the obligation as receiver and manager. Then within the stock administration, the purpose of administration is not only to rescue the business, but to also take care of the creditors' obligations, the debt of the creditors. So the administrators, upon assumption of office, will be able to, remember, it has within the law the right to employ any experts. So he can look at the business, and depending on the manner of appointment, because within the newcomer and even with under the insolvency regulation of 2022, the administrator can be appointed by the shareholders or the members of the company, or by the floating charge company, that is the creditors. And the obligations and the circumstances are entirely different, including the reporting line. So for us, I think we need to understand the nature of each engagement and then the legal obligations expected or required of the insolvency expert or insolvency practitioner who is engaging in this matter. And again, in terms of moratorium, they mentioned, it can even be extended beyond the initial 6 months under administration. It can even be further extended. But the difference, unlike what has been said under the Singapore law, is that upon filing, you have automatic 1 month. But within the Nigerian law, you must bring an application, and that now leaves all the relief that may be sought along that line within the discretion of the courts. So you must convince the court on the need to grant the moratorium. Because once you can make that application, the court has a discretion, power to either, the available options are there. Thank you very much.
Sorry, let us. Sorry, the issue of privacy. What about that?
Well, the issue of privacy, in terms of privacy, of course, we know that all matters that go to courts, any person is entitled can do a search or make inquiries about those matters. It can be, unless where there are special applications granted for the matters to be heard in chambers or privately. Outside that, I mean, you are not going to force somebody to leave the court. So the issue of privacy is limited to an extent. But the administrative processes in the insolvency can be undertaken privately.
Yes.
But the judicial processes, there is, unless by application, the court can allow such private engagements. Thank you.
Thank you. Somebody, you wanted to say something? Yes.
So let us look. I said, let me just a bit. I mean, rising from my experience with administration, sir, the relevant section is section 480, and the side note is very clear. It calls it moratorium, right? In certain cases, it has 5 subsections, very copious. The framers of the law did extensive work there. And what is interesting there is that when I did my administration, right, I held the taxman down. The taxman could not bring a tax claim during the course of my administration. I relied on these provisions to say, no, you can't collect taxes. Now I'm in charge. You're a creditor, just like any other creditor. I will prioritize you, right? And yes, just like Leonard Silk said, student said, it is not limited to 1 year. Once the company is in administration, right, all legal cases, any claim whatsoever on that company ceases. And jurisprudence of that is this: let the administrator break. Let the administrator do his work. It's come to rescue. Do not hamstring him. Let him give him all enormous powers. So that's why we say administrators need to be very careful. I mean, to whom more responsibility is given, to whom
much is expected. Thank you. Before I close this session and thank the speakers, I wonder if we have bankers here. Recently, I was at a forum and some discussion was going on about why are creditors, banks especially, even from inception, when they lend, they have some sort of contractual provision whereby they can either embed
uh, people, maybe in management, where such that as soon as they see red flags, they are coming in maybe informally, to advise or to uh, caution or to, let the borrow, because in a lot of these matters of business, lady, prevention is actually better than waiting for the event of default and then the creditor comes in and wants to wield a big stake. I mean, naturally, a bank wants to simply go in and recover his funds. But in a good number of situations, if they are really paying attention or maybe attending board meetings, they'll be able to spot very early on when problems are already brewing. Do you want to say something, Justina? You've been in the bank. I mean,
Yes, I've been in the bank, but I'm now in practice. So anyway, um, yes, the banks are not interested in losing customers or for the debtor to lose his business. So why the advice and why the early why do we dictate early red flags is to bring it to the fore. We have gathered some people's monies and we have handed it over to you. We have responsibility to ensure that when that person comes back to take his money, we can make it available. We do not want a situation where you come for your money, we will tell you that there's no money. And you know how words spread like wildfire. Once one person can't get their money, they will say that bank is distressed. So that is why when we dictate early red flags, we call the customer and put them on notice. Why is your business going down? Why haven't you been able to pay? Remember or recall that you have repayment terms. So they must be strictly adhered to. You do not allow the time to elapse and then you don't follow. So as a matter of fact, there's a department that monitors that. Risk management. That is what they do. So when we do that, if there's something that we can easily rectify, we do that and the customer is happy, his business is progressing, we are making the money and he's repaying. Thank you.
thank you. Thank you, ladies and gentlemen. Let me thank the speakers. Mr. Oji Okwechi, thank you very much. And Mr. Mechi, who has come down for letting us have some snippets of your knowledge and experience. Mr. Sesu Famabi, from your presentation is what has led me to ask one or two questions about the steps, how to prevent some of these brewing troubles. Jote from Singapore, thank you so much for your presentation. I'm sure practitioners here will be looking more into the Singaporean experience and see what we can borrow to benefit us. And lastly, Mr. Olumide, you've given us an opportunity to look at another perspective to the whole insolvency regime with the GLR. Thank you for all the efforts, preparation. Usually the presentation takes very short time compared with the preparation that has gone into it, but that is the way conferences are. Thank you, ladies and gentlemen, for your time and your attention. God bless you all. Thank you.
Ladies and gentlemen, please put your hands together. This has been a very interesting session. Please, I'm sure you know they deserve a better round of applause. Please put your hands together for everyone on stage right about now.
Thank you very much for your patience thus far. At this moment, we are going to be inviting Mr. Ayodele Akintunde, SAN, FCIR, UK, CAB, and Fellow of BRIPAN for the presentation of gifts and appreciation.
You have played. Can't give you this one.
Yeah, offices. Thank you, sir.
Thank you.
Photo session, may we have a little bit of music in the background?
Now to the presentation of gifts. Our distinguished speakers, Mr. Austin Jackson. Mr. Oji Okweji, on behalf of the Council of BRIPAN, we appreciate you for participating as a speaker in this session, and we thank you for your very useful insights into using insolvency tools for enforcement of awards. Thank you very much.
One house, ladies and gentlemen, please, may we have your attention? Please, kindly bring the noise down. Thank you.
The doctor.
Last. Right.
Thank you. Mr. Sesu Famade, on behalf of the President and the Council of BRIPAN, we thank you for attending this session as a speaker and for your very useful insights into using insolvency tools. Thank you very much.
May I have ushers at the stage assisting with the packages, please? Ushers, kindly assist our speakers with their packages.
Yes, on behalf of the President and the Council of BRIPAN, we thank you, Mr. Bidemi Kolumide, who is also a council member, for your very useful insights into how to use ADR tools in deepening insolvency. Thank you very much. We appreciate you.
Yes. Yes, sir. Thank you.
Here, the chairman. There you go, sir. Well done, sir.
On behalf of the President and the Council of BRIPAN, it is my pleasure and honor to present to our distinguished founding president, founding member, and past president, Dr. Lionel SAN. We thank you very much for anchoring this session and also enabling the speakers to give their insights into the topic. Thank you very much.
Thank you.
Babani, founding president.
No.
Corrected.
I'm on the for good message.
Yes, yes.
Well, don't want anybody to come and talk.
So much of story.
Oh,
Story.
All right. I'm sure you agree with me that it has been it was an insightful first session we had. We'll have the second session shortly. But before we do that, we know that we have breakfast, tea break going on. So in the meantime, would like to welcome the chairman, Nigerian Bar Association Lagos branch, in the person of Uchenna Ogunedo Akimbade. Please, can you put your hands together for her? Great to have you here with us today. The very beautiful. Good afternoon, distinguished guests, Leonard Silks, my lords here present, esteemed speakers, colleagues, and fellow professionals. Let me first of all start by apologizing that I missed my earlier slot. I was at the Pro Bono Week being organized by the Lagos State government, and the program started a bit late, and that impacted the time that I could get out. Sorry, ma'am, sorry. Distinguished ladies and gentlemen, please may we be seated. Madam Uchenna has the floor. Please may we be seated. Thank you, sirs. Thank you, sirs. Thank you, Maz. Please may we be seated. Please may we be seated. Thank you, sirs. Thank you, sir. Yes, sir. On behalf of the Nigerian Bar Association Lagos branch, I'm delighted to extend felicitations to and members of Business Recovery and Insolvency Practitioners Association Nigeria, BRIPAN, on the occasion of your 2025 International Conference. The theme, Solvency Tool for Restructuring Commercial and Financial Challenge Businesses, resonates deeply with today's realities. Across the globe, businesses, governments, and individuals are grappling with economic challenges and uncertainty. These pressures have reshaped the practice of insolvency, moving it beyond the narrow confines of liquidation or receivership. Insolvency practice today is about safeguarding livelihoods, protecting stakeholders, and creating frameworks for renewal and sustainable growth. Modern tools, including business rescue, administration, restructuring, and turnaround management, emphasize continuity over closure of businesses, focusing on stabilizing distressed businesses, preserving value, protecting jobs, and ensuring that creditors, investors, and communities are not left behind. The insolvency ecosystem thrives on the collaboration of diverse professionals, with lawyers playing an indispensable role. We draft the frameworks, advise on compliance, advocate before the courts, and support businesses navigating recovery. Legal practice, thus, plays a pivotal role in insolvency process, ensuring that restructuring efforts are legitimate, credible, and impactful. This is why over the years, the MBA Lagos branch has been intentional about strengthening its collaboration with BRIPAN.
We have coordinated members to attend BRIPAN trainings. As a matter of fact, last year I was the lead coordinator for the MBA Lagos BRIPAN collaboration that saw over 250 members of the MBA Lagos get inducted as BRIPAN members. And that collaboration still subsists. A lot of the people in this room are MBA Lagos members. A good number of us are on the conference planning committee, including myself. That shows you the value and the importance that we place on BRIPAN and insolvency practice generally. Our trainings have equipped our members with the skills and accreditation required to function effectively as insolvency practitioners. For many lawyers, insolvency knowledge is not only a professional asset, but also a practical tool in managing their own enterprises. And I must say, even personally, I have learned a lot from being a member of BRIPAN, which I have deployed in my own private businesses. Properly managed insolvency restores businesses, preserves jobs, protects stakeholders, and strengthens the wider economy. It is our hope that conversations at this conference will inspire reforms, strengthen frameworks, and promote ethical practices that sustain businesses and bolster Nigeria's economy. On behalf of the Nigerian Bar Association Lagos branch, I once again congratulate BRIPAN for convening this landmark conference. I encourage all participants to engage in enriching deliberations, fruitful networking, and enduring collaborations that will shape a stronger future for insolvency and restructuring practice in Nigeria and beyond. Thank you.
Thank you, ladies and gentlemen. Would like to recognize a few people in the house today. Would like to recognize Mr. Shola Oyetayo, FCA, past President BRIPAN. It's so great to have you here today. Would also like to recognize Mr. Abiodun Anifowoshe, FCA. Good to have you as well. Would like to recognize Mr. Olawale Saliu, FCA, and of course, Mr. Omokide Kamilu, FCA as well, and Mr. Kehinde Folorusho, FCA. It is so great to have you here today. Would like to recognize Mr. Abiodun Andu, who is in the building today. We also have Mr. Bunyamen Lawal, SAN, here with us today. It's so great to have you here today. Now, I know that a lot of us are feeling like, you know, when you tell little children, sit down, we want to play a little bit. So we'll take a quick 15 minutes tea break. For those of us who have not gotten our tea, please, you can do so. If you need to use the bathroom as well, I know we have it on the first floor, just the floor right after this. So please, you can take a quick 15 minutes bathroom break and your tea break. You can also network. You can do your photo sessions right now as well. And in the next 15 minutes, we'll be back here for the second session, which you don't want to miss. And of course, for that session, we'll be taking market insights and outlook. Distinguished ladies and gentlemen, it is the BRIPAN Conference 2025, and it has been amazing thus far. We cannot wait for the second half, which we definitely know will be way better than the first. Thank you for your time. Music.
pump. Your love the ginger me, body the pump. Now you the light up my dark. You beside. Shake fellow, yeah, my soul. Shake fellow.
Sponsors, basic support group. Without you, this conference will not be possible. Preston Peterbu, we thank you. Thank you for all you do. All the brands that have stood solidly behind BRIPAN. Thank you for paying the price. Thank you for believing in the vision. I would like to recognize the presence of Mrs. Kike Lomo Abikele, FCA. She is here with us today. Would also like to recognize Mr. Yinka Adesoya, FCA. Good to have you. Special recognition for Mr. Gbenga Badejo. Thank you so much for being here. And of course, today we have Mr. Wale Adewale, FCA. Mr. Taufik Murtala, FCA, is with us today. Special recognitions. Distinguished ladies and gentlemen, we are ready for the second session, so please may we settle down. Thank you, thank you, thank you, thank you, thank you. Time is not our friend. We need to harness it and utilize it effectively. So please may we settle down. We need to start the next session. Some of you will meet me in court too. All right, distinguished ladies and gentlemen, please settle down. Please, please, please. All right. Second session, market insights and outlook. Already sounds interesting. We'll be looking at the Investments and Securities Act of 2025 extensively. Also look at Nigeria and what it's currently witnessing as a significant overhaul and reform of its tax law work frame. And for this session, we have our coordinators. We have Foluke Akimoladun, who is the Managing Solicitor, Treason Law Chambers. And of course, we've got Agatha McMadu, Principal, Agatha Law Firm. Please put your hands together for our coordinators. They will be taking over this session. Mona, clap now. Easy. Thank you.
Good afternoon, distinguished ladies and gentlemen. As earlier introduced, my name is Foluke Akimoladun, and with me,
Agatha McMadu, the founder of Go.
Our session this afternoon is on market insights and outlook, and it's going to have a number of speakers, 4 in total. The session chair is Mr. Amechi Insofo, partner, Grant Thornton UK Advisory and Tax LLP. The first topic is going to be an insight into the new insolvency carve-outs in the Investment and Securities Act 2025. The speaker is Franca Chukwuogo, the Executive Commissioner, Legal and Enforcement of the Securities and Exchange Commission. This will be followed by a presentation on the Nigerian new tax regime, implications for insolvency processes, which will be presented by Mr. Albert Folorunsho, FCA, FTI, ADIT, FBR, Managing Consultant, Creston Pedabo. And this would be followed by a presentation on strategies for dealing with non-performing loans and distressed investments. And the speaker is Luke Tucker Harrison, who is the partner of Caden Harrison LLP UK. And the last but certainly not the least is resolution of banks and OFIs under BOFIA 2020 and the NDIC Act 2023, matters arising. This presentation will be handled by Mr. Kushimo Olufemi Oladipo, Director Legal, NDIC. We will now be briefly taking the profiles of the speakers, and please we'll kindly like to implore for the speakers who are in the room, as your profile is being read, please make your way gracefully up stage. Thank you.
In no particular order, I present to you the corporate profile of our speakers. Frana Chukwuogo is the Executive Commissioner, Legal and Enforcement at the Securities and Exchange Commission. She has over 25 years experience in the legal and capital market space, advising on policy, regulation, enforcement, and legal matters. Prior to being appointed to the Executive Commissioner position, she headed the legal department of the SEC and acted as technical advisor to the same institution regarding high-profile investigations and enforcement actions, market structure, and articulation of progressive rules to guide market conduct. She also worked in the first investment bank in Nigeria, FCMB, managing private wealth and investment portfolios. Frana has an LB from University of Jos, Nigeria, a master's degree in international economic law from University of Warwick, United Kingdom, and a master's degree in securities regulation from the University of Pennsylvania, USA. She's a capital market fellow of the IFC, Milken Institution, and licensed to practice law in Nigeria and in New York, USA. She's ably represented by Onyedikachi Ogbonne Ede. Onyedikachi is alumnus of the IFC Milken Capital Markets Program and the technical assistant to the Executive Commissioner, Legal and Enforcement at the Security and Exchange Commission, Nigeria. Before joining the SEC Nigeria, Onyekachi engaged in private legal practice, and after completing the mandatory National Youth Service, Onyedikachi recently obtained a graduate certificate in capital markets from the George Washington University School of Business in the United States and holds a degree in law from the University of Nigeria in Nsukka. He was called to the Nigerian bar in November 2009. The next speaker, Mr. Albert Folorunsho, Managing Consultant, Creston Pedabo. He is a fellow of a number of international and domestic organizations, including ICANN, CITN, and BRIPAN. Mr. Albert has been involved in all aspects of taxation practice, including international tax advisory, transfer pricing planning and implementation, and oil and gas taxation management. He has also handled several insolvency assignments from financial institutions, including debt recovery, liquidation, receivership management, and business restructuring. He is an international affiliate of the Chartered Institute of Taxation of UK, with specialization in UK and European taxation. Having been awarded the prestigious Advanced Diploma in International Taxation with wide experience in international taxation and advisory involving cross-border structuring and transfer pricing, and has lectured on business and advanced tax management almost 2 decades. Albert co-founded Kristen Peterborough in 1998 and is presently the managing consultant of the firm. The next speaker is Mr. Luke Tucker Harrison. Luke Tucker Harrison is an international commercial disputes lawyer with particular expertise in insolvency restructuring, fraud, and asset recovery. He has significant experience handling complex and high-value insolvency and restructuring disputes and advisory mandates, often involving international elements, allegations, and asset tracing. Luke has acted on a wide range, high-value, and complex insolvency matters. In 2024, Luke acted for a director of British Home Stores in a claim pleaded at over £100 million arising from its collapse. He also acted for Charles Gordon in Refined London Limited and others. 2021 EWHC 1950, opposing efforts to expand claims involving property register rectification following the winding up of his portfolio companies. He is currently representing the defendants in Emirates NBD Bank PJSC and Emirates Islamic Bank PJSC versus Yazdi and others, a £50 million investment enforcement claim linked to proceedings in Dubai, defended on the grounds of alleged fraud, natural justice, public policy, and human rights. In this matter, he successfully obtained significant disclosure and information orders ahead of a trial scheduled for 2026. Thank you. The next speaker, Mr. Kushimo Olufemi O. Mr. Kushimo Olufemi is a seasoned legal practitioner with over 3 decades of experience in deposit insurance law practice, corporate law, financial regulations, and public sector governance. He currently serves as the Director, Legal Department at the Nigerian Deposit Insurance Corporation, NDIC, where he provides strategic legal oversight in strengthening the regulatory framework for deposit insurance, banking sector, and the Nigerian financial institution. His wealth of experience spans deposit insurance, liquidation, corporate governance, litigation management, and regulatory compliance, particularly in the banking and financial sector. Renowned for his analytical rigor, expertise, deep commitment, and experience in bank liquidation, Mr. Kushimo brings a unique blend of strategic insight and cognate experience to the BRIPAN International Conference. The session chair and moderator, Mr. Amechi Nsofo, partner, Grant Thornton UK. Amechi Nsofo is a partner at Grant Thornton UK, where he leads the firm's Africa practice. He specializes in restructuring, insolvency, and sovereign advisory services, with a particular focus on supporting African companies, governments, and institutions in navigating complex financial and legal challenges across borders. As a seasoned restructuring and insolvency practitioner of over 20 years, Amechi has considerably experience in helping financial stakeholders protect and maximize value. His specialisms are providing a soft line for distressed entities and asset recovery on behalf of claimants. Amechi's team has pioneered the use of insolvency powers to facilitate litigation, trade, and recover misappropriated assets for the benefits of claimants. In the last 8 years, the team has delivered successful recoveries in the region of $4 billion from over 65 jurisdictions. In addition to his role at Grant Thornton, Amechi recently completed 2 full terms as a board member of the Institute of Directors UK, where he co-founded the Africa Special Interests Group. This initiative was established to foster stronger business ties between the UK and African markets and to support African professionals in the UK business community.
Ladies and gentlemen, I'll hand you over now to our session chair, Mr. Amechi Nsofo, to take over from here. Thank you, sir.
Thank you. Thank you, everybody. I want to say special thanks to the coordinators for such a detailed introduction. I think this is one of the few conferences where I've been at that we are at risk of the introductions being longer than the actual panels themselves. But having said that, I was told to keep my introduction brief. Otherwise, we're at risk of some of us in this room entering into personal bankruptcy. So without further ado, I would like to call on the panelists who are going to be giving a talk on various areas which span tax, it spans non-performing loans, and it also touches about on insolvency carve-outs in the Investments and Securities Act 2025. Just before I do that, I want to say it's an honor for Grant Thornton to be the headline sponsor at this conference. We have a very long established relationship with BRIPAN and also with BRIPAN partners outside of Nigeria, including the INSOL, Africa Roundtable, and also the World Bank Group on insolvency. So this panel brings together some of the experts that you're going to be hearing over the next couple of days. And they're going to be touching upon issues that will shape the development of insolvency in Nigeria, both from a corporate rescue point of view. And insolvency is very important because it's one of the mechanisms through which the financial stability of any country can be maintained. Now, I know Frana cannot be with us today, but she will be represented. Frana is the Executive Commissioner, Legal and Enforcement at the Security and Exchange Commission, but we'll hear from a colleague of hers who will give us an insight into the new insolvency carve-outs in the Insolvency and Securities Act 2025. So could I just hand over, please, if you just carry on from here. Thank you. Do you understand? Oh, yeah. Okay. Thank you.
Good afternoon, ladies and gentlemen. Permit me to already observed protocol. And my name is Onyedikachi Ede. I am not the she who is Frana. I'm the he who is assisting her. All right. Okay, so I will quickly try to touch something that is very important to us at the Securities and Exchange Commission, and which I believe you will also find very interesting. There are two preliminary comments I wish to make. One is that laws are like insurance contracts. The risk that is being insured may not happen, but if eventually there was no provision for the risk, let us start from the general and then we progress to the specific. So I will just do a brief whoever is controlling the slide, this should be slide excuse me. Okay, this should be slide 4. Okay. Slide number 4, please. All right. So just looking briefly at the general provisions in CAMA, and then we now link it to what we did in the Investment and Securities Act. So the CAMA 2020 is the act that has comprehensive provision regarding insolvency and winding up of companies in Nigeria. There are specific sections that address appointment powers of liquidators, committees of inspection, special managers, and official receivers. It also provides for the process for declaration of solvency, meeting of creditors, and other matters. It also establishes rule of insolvency practitioners' qualification, authorization, and regulatory oversight. And most importantly, the insolvency framework created under CAMA applies to companies broadly and includes detailed procedural, supervisory, and dissolution provisions. So CAMA provides the general framework for insolvency and business recovery in Nigeria. So what have we done? CAMA also has netting provisions, specifically chapter 28, which covers sections 718 to 721, addresses netting agreements, and it is the first time netting is being introduced into Nigerian law. It defines netting concepts and accords enforceability to netting agreement, even in insolvency scenarios. Section 721 provides that netting agreements are enforceable against insolvent parties and guarantors and cannot be stayed or avoided by liquidators or insolvency practitioners subject to agreement terms. One thing that is very key about the provisions in CAMA relating to netting is that for any netting claim or arrangement to be enforceable, it must be specifically contained in the contracts. That is very key. If there is no netting arrangement contained in the contract between the parties, then it cannot be enforceable under CAMA. I had to emphasize that because that is one major area of difference that the ISA has introduced. All right. Okay. So most of the instruments listed in section 718 under qualified financial contracts are mostly capital market products. That is very important. If you look at section 718, where it listed qualified financial contracts, most of those instruments, derivative contracts, and all that are mostly capital market products. Then section 719 also allows financial sector regulators such as the SEC to designate other instruments that are not listed in section 718 as qualified financial contracts. Now, CAMA netting provisions is only applicable where expressly provided for in the agreement. Now, that takes me threat to the provisions in the ISA. The ISA 2025 introduces new regulatory provisions addressing insolvency of financial market infrastructures, FMIs, and capital market operators that are distinct from the general provisions made in CAMA. Okay. The Act establishes, creates legal recognition and regulatory oversight for virtual assets, security exchanges, commodity exchanges, warehouse receipt, and the related insolvency impacts. It features a specialized insolvency framework for FMIs, that's financial market infrastructures, to address their unique transactional and operational characteristics. May I pause there to summarize what the ISA seek to achieve here? Financial market infrastructures are infrastructures in the capital market, including the exchanges, the settlement houses, and trade depositories. All those facilities, they are all together referred to as financial market infrastructures. Now, if you are familiar with capital market transactions, one of the things that give confidence to transacting parties is the level of risk that has been taken by the FMI. In other words, between the transacting parties, the FMI stands as the counterparty to each transacting party. That arrangement takes away the counterparty risk in transactions that happen within the financial market infrastructure. I hope I'm not confusing us. All right. So that risk that is assumed by the financial market infrastructure is very significant to the extent that it could cause a lot of ripple effect in the system if there should be maybe a failure of one of those financial market infrastructure. Now, it is from that background that the idea of having statutory netting provisions as well as specific insolvency carve-out for the FMIs became important. And FMI could, maybe in a day, an FMI could execute up to, let's say, 1 million transactions. Now, if an FMI executes 1 million transactions in a day, for instance, and there is no netting provision, what that means is that if there should be a need for the FMI to undergo liquidation or any other form of insolvency, each of those contracts will be treated as a distinct contract. And you can imagine how overwhelming that could be. So the idea behind the provisions that has been made in the Investment and Securities Act is to make it a lot more easier to unwind or to net out such transactions during insolvency. Okay. The second thing that the ISA has done is to strengthen the power of the SEC during, of course, let me say, starting with the management of systemic risk, because before an FMI would fail, there will be obvious signs. So in order to not to allow an FMI to fail just so suddenly, there are powers that have been given to the SEC, including powers to suspend trading for 14 days and other similar powers. If there's a bit of a shaky environment or a stormy financial, environment, the SEC could intervene to be able to moderate things. But if eventually the FMI fails, then it proceeds to the next stage, which is the insolvency stage. Okay. So the philosophy behind the provisions in the ISA is to moderate the application of general insolvency law to significant capital market infrastructures, thereby ensuring market stability and modernized oversight. It's also very important to know that markets today are global in nature. Markets are no longer isolated if they ever were. Today, markets are highly interconnected. And one of the things that, let me say, foreign investors will look out for before deciding to invest in your own environment is the kind of legal regime you have. If, for instance, we do not have provisions that give that assurance that contract, that financial contracts that were consummated through the financial market infrastructures are safe and final. If there is no sense of finality in those contracts, then our market will be unattractive to global investors. So it is also one of the rationale for making the provisions that you find in the Investment and Securities Act. Now, what are the critical innovations introduced by the Act? It has ring-fenced financial market infrastructures. Market contracts, including those executed through the clearinghouses, repos, and the rest of them are exempted from CAMA insolvency rules. What the Act has done is an FMI today will be required to have its own default rules. Its default rules, the provision of the ISA says that in the event of an insolvency, the default rules of the FMI would take precedence over the general provisions of CAMA. So an FMI would have its default rules, and those default rules will be the first point of call in case of an insolvency. It is only things that are not contained in the default rules that recourse would then be had to the provisions of CAMA. Now, the FMI default protocols would override the general provisions. Okay. Further highlights, there's immunity from insolvency law, transfer orders and collateral security via financial market systems are protected from insolvency effect. And that's what I explained about finality. Priority for market infrastructure, I have also explained that. Limits on court powers. The third element or the third feature that the ISA introduced is a kind of providing a guide for judges that handle insolvency matters when it has to do with financial market infrastructure or financial contracts. Then the judges are required to exercise some level of deference to the provisions of the ISA. Timing also matters, and then there is no retroactive impact. Insolvency proceedings cannot affect proceedings rights and obligations. The other thing that I think is also very important is that the Act made provision that Nigerian courts will not enforce judgments or orders that are given by foreign courts when those orders or judgments do not accord with the regime we have locally. In I'm so sorry. Okay, so let me time up. I have mentioned a few things that are um, you may consider the comparison between the provisions of CAMA and ISA. The most important thing I want to drop with us is that the provisions in the ISA are not meant to conflict with the provisions in CAMA. They are rather made to complement the provisions in CAMA when it has to do with financial contracts that are transacted or consummated using the financial market infrastructure. Thank you.
No, thank you very much for that. I think for what you didn't notice sitting out in the audience was that the teleprompter is not functioning properly today. I think Donald Trump had the same issues at the United Nations General Assembly a couple of days ago, and heads are going to roll in New York anyway. I'm not sure about in Nigeria. So we heard very briefly there about systemic assets and how the insolvency framework in Nigeria is evolving to deal with those systemic issues or matters that might pose a systemic risk to the country. And that's where my understanding is that the ISA provisions really come into the fore. It's not a replacement for CAMA. It's there to support and to complement the provisions in CAMA when it comes to dealing with the FMIs, which we might go into later. So in terms of how this process is going to work, later on, we'll be taking questions from the audience. So I do want you to get your questions ready so that we can challenge our panelists who come up here to speak to us today. Talking about those panelists that come up to speak to us, we're going to move on to the Nigerian tax regime and the new tax regime and what implications that new tax regime has for insolvency processes. So I'd like to invite Albert up, who's the managing consultant at Creston Pidabo, to give us a talk on that. Thank you very much.
The chairman is giving me 20 minutes. And he knows that those streaming have not been fully paid. So I'm sure they will not put up any time off for me. Good afternoon, everyone. It is my pleasure again to come before you to discuss tax. I'm sure it's something very important that I believe all of us will pay proper attention, particularly what is likely to happen from January 2026. You are privileged to have me as a member of the Presidential Committee on this tax reform. I'll give you a brief highlight, and then I will zero in on the specific provisions that relates to insolvency. I'm sure we're familiar with the fact that before now we have had several changes to the Nigerian tax law coming in through the Finance Act that was being issued on a yearly basis. That has tried to bring Nigerian tax to some level of compliance with the reality of time, but we observed that there are so many of those laws that it was impossible to correct using the Finance Act, and that was why the wholesale reform that we have now has taken place, which covers virtually every facet of Nigerian taxation. And we are familiar with the fact that 3 laws have been issued, one covering the fiscal aspect of Nigerian taxation, which we call the Nigerian Tax Act. Then we have the one that covers the admin aspect of the taxation, the Nigerian Tax Administration Act. And then we will have one that covers the responsibilities and duties of the Nigerian Revenue Service, which is, we used to know, or is still called the Federal Inland Revenue Service. And then, of course, we have the tax, the one that has to do with the revenue, Joint Revenue Board that encompasses all the tax revenue authorities in Nigeria. from federal to state and local government. And we know they all have their specific provision. Now, under the Nigerian Tax Act, which is majorly the fiscal aspect of the Nigerian taxation, it outlined a lot of the provisions that we have under separate laws before now. We used to have the company income tax, the capital gains tax, personal income tax. All of that have been subsumed into what we call the Nigerian Tax Act. And that is where we have the main provisions of the law, where we're going to have a brief highlight. Now, one of the highlights which has become very relevant is the fact that all Nigerians must have their tax identification number. You know, that has constituted a lot of conversation in the last few weeks, and people are of the view that, is it that by January, banks are going to freeze any person's account that does not have the tax identification number? But that is not true. The truth is that all persons, if you are a company, your corporate tax registration number is the reference for determining your tax identification number, and automatically CAC normally give you your tax identification number now. And then for individual, which is one that is very close to our pocket, is the fact that for individual, your NIN number will be taken as your tax identification number. So if you don't have one, automatically the Joint Revenue Board will liaise with NIN and then communicate same to different banks. Banks are already working on ensuring that they don't fail to comply with the fact that every individual must have their tax identification number. Which they are going to incorporate into your account. That is very important. They are not going to be forceful in terms of the implementation, but they are going to engage individual in a very in a manner that will not disrupt the system. Okay, some of the major highlights of the changes that we have, which are also critical, is the fact that we now have capital gains tax being taxed at the rate at which individuals pay their individual taxes. Of course, the whole provision is that CGT was at the rate of 10%, right? But now it depends on your tax rate. If you're a company, your tax rate is 30%, you pay your capital gains tax at 30%. If you're an individual, depending on your income profile, remember we have a graduated tax table of rate that ranges from 0% for those who earn 800 and below. And then if you earn the next level is 15%, that is if it is not more than 2.2 million. And then the next one at 9 million, you'll be at 18%, 21%, 23%, and the highest rate now is 25%. So whatever bracket that you fall in will determine the tax rate that is applicable to you. Again, we now have a threshold for businesses that will be liable to tax. The threshold is definitely 100 million, not 50 million. I know there is, a controversy as to what is stated in the Nigerian Tax Act and what we have in the Nigerian Tax Administration Act. One says 50 and the other one says 100. But the intention is truly, and the position is 100 million, which means if your turnover as a business is 100 million and below, you are exempted from tax. Of course, there's a provision now that also says that companies, businesses, whatever level of business you are doing, if you don't make profit, you are not liable to tax. The whole provision relating to minimum tax of 0.5% of your turnover has been removed. But there is a hidden minimum tax which applies to multinational. If your turnover, or you're a member of a multinational group that earns turnover of not less than 750 million euros, and you're a member of that group, okay, there is a minimum tax of 15%, which applies to your profit before tax. And that is also majorly for multinational. But that has also been extended to big businesses in Nigeria. When we say big businesses, we mean those who have turnover of not less than 50 billion. If you're a Nigerian entity, you are not a member of a multinational group, and you earn turnover of not less than 50 billion, you are liable to a minimum tax of 15% of your profit before tax. All right, those are provisions that we have, which we have to deal with. If you look at the Nigerian Tax Act, there are also provisions that are related to the processes of the court, particularly as to, in the Nigerian Tax Arbitration Act, there's a provision relating to the tax ombud and the process for tax appeal tribunal. all right? There are controversies as to whether the processes of the court, I mean, the law of evidence should apply or should not apply. But I think they have concluded on that fact that as far as tax appeal tribunal is concerned, you don't need to implement the real provision of evidence such that you can allow individuals to represent themselves in court. That is a brief overview. I know my time is running. I will now go to the main gist of how it affects the implications of tax reform on business restructuring and insolvency. And the first point is the fact that it is the responsibility, if you look at section 53, subsection 1 of the Tax Act, it prohibits a liquidator, if you are a liquidator, from distributing assets to shareholders until all taxes, including withheld taxes, have been fully paid. When Olumide was speaking, I told him that, that your story cannot work based on the current law. Yes, you can be looking at the provision of KAMA, and then we're looking at the provision of the Nigerian Tax Act. And then we want to see which one is superior at the end of the day. But we know in section 657 of KAMA, which also classify tax liability as what? As preferential debts in a solvency proceeding. The tax can be assessed in the name of the receiver, if it's the receiver that is in charge, a liquidator, an administrator, as though is the owner of the business, or as if the person is a company. That provision is very clear. Again, there are provisions relating to taxation of dividend. Any form of distribution by a company to the shareholder is classified as dividend, whether it is in cash or in kind. Of course, the only distribution that is exempt from tax is where you issue bonus or scrip issue to the shareholder. Any other form of distribution constitutes dividend, and whatever way you want to apply it, withholding tax of 10% must apply. Okay, that is in the provision. Then in section 24 of the Nigerian Tax Act, there are provisions relating to cessation of business. Of course, in the case of insolvency, there is a likelihood of liquidation or businesses coming to an end. And then there are provisions that must be applied as a liquidator or as a receiver or as an administrator. If it gets to that level, that you must file your return, there must be cessation rule that will be applied to the business, and that provision is stated clearly, which means the profit of the last year from the 1st of January to the actual date of cessation must be filed, and the company must be subjected to the appropriate tax on that. Then if you go to, yes, I've already explained which has to do with loss-making company. I'll just move on straight because of my time. Then we now have some very interesting provision relating to business restructuring and mergers, acquisition, takeover, okay, which is some of the things that can happen in the course of insolvency, particularly when you are preaching business rescue. And that is in section 190 of the new Nigerian Tax Act. Okay, it talks about a merger, where two companies merge, it can be in different form. Either you merge two companies and then one will a new company will spring up and continue, or one subsume the other and you trade in the name of one of the two. Whatever way you do it, the provision is the fact that the commencement and cessation provision in the law will not be applied, which means the different entities will not be deemed to have started or ceased a trade. Okay, they will be treated as if they are continuing in business. So the assets of the company that are being merged will be taken at what is called their tax written down value. You're not going to, you will not use the actual cost or the value at which the assets are exchanged, right? Then the losses of company A that is subsumed into company B will be allowed under this new provision now. The surviving entity will be allowed to take the losses of the subsumed entity and use it to relieve the profit accruing to the surviving entity going forward. The same thing also applies where company A has a withholding tax credit, which means certain sum has been deducted from your, from your income in the course of transaction, and you have credit notes, which means federal government is owing you. And then there is now a merger or takeover. Before now, the tax authority will always say, no, go and claim refund. And you know it's not easy to get a refund. If you apply for refund, if you are not too sure, you end up owing so much. In fact, you will regret applying for refund sometimes. So the good thing now is the fact that where there is such arrangement, the surviving entity is allowed to use the unutilized credit note of the subsumed entity, in relieving the tax liability of the surviving entity, which is very good, which is everyone is very happy about. But of course, where you have a sale or a transfer resulting in a takeover, the old provision relating to commencement, cessation, value of asset taken over and all that will also be applied. And then there is not too much joy when it comes to that. Again, there are provisions in the law that has to do with treatment of debt forgiveness. Before now, what we have is where an expense has been charged into the book of a company, or maybe, yes, I've been charged into the book of a company, and that expense is waived or relieved. The provision is that such will be taken as if it's an income of the business. But what we now have in the law is such that where there's any forgiveness, a lot of people now engage with the bank. You want them to restructure the loan. You want them to even waive. You cannot even pay the principal, not to talk about what? Interest. So the interest on the loan, you have already charged it as an expense in your book, and you are unable to pay the loan, and the bank is saying, I waive it. Because they are waiving such interest, it is taken as if you have earned what? Income. And for tax purposes, you will pay tax on that interest that is waived. Unfortunately, that is the law. Then the next point, the next point is the fact that, apart from having some level of restructuring where interest is waived, I have seen telecoms companies or some other companies that are heavily indebted to banks to the extent that bank was willing and they actually waived some level of the principal. Okay? It is possible to waive principal. Just pay what you can pay and go away. I'm tired. Where a principal sum is waived, the provision of the law is that the person who owed the debt has disposed of an asset and has generated a capital gain. And that capital gain will be subjected to tax. I don't know whether you people are owing. I'm talking about those who are owing. Okay, as I round up quickly before the if you are going into any merger or acquisition or takeover, the requirement of the law is that you must obtain the approval of the tax authority, and that remains. It's not that you are obtaining the approval. The provision actually says you should notify. Okay, so which means if there is any form of restructuring you are going into, company A merging with company B, or companies have been owing each other and you want to have any form of arrangement, you must notify the tax authority. Another provision which is very key that has come up under this new law is the fact that if you have any tax planning arrangements or you want to avoid tax by any form of way, there is a provision in the law that says you should give notification to the tax authority that I'm going to do something, otherwise it will be taken. It will be taken. It is referred to as aggressive tax planning or avoidance schemes. Yes, we know that avoidance is not criminal, right? It's allowed. But the current provision says you must notify the tax authority so that they can be aware. Right. Yeah. Thank you so very much. Let me stop here before.
Right. I think that's the first presentation on tax that has ever generated such reactions from the audience. But just let's be clear from an accountant's perspective. the concept of writing off a loan or writing off interest on the books of the company, that creates a credit because you have taken the interest deductibility as an expense in the past. So if you end up not paying that interest in future and that loan is written off, then there has to be a credit that the company incurs. I want to come to some practical questions around the intersection of tax and the insolvency framework in Nigeria. But please, if you can submit your questions to us. I think we have someone on stage who has a problem with tax. He's he's getting some free tax advice. No, so he's getting some free tax advice. We'll send him an invoice at a in a short while. Right. We are joined now by my good friend who cannot be with us today, but he's joining us from the UK, from London. So Luke Harrison is an expert on a matter that's very close to my heart, is on contentious insolvency and restructuring. And having practiced insolvency in Nigeria for a number of years now, I know that every single insolvency in Nigeria tends to be contentious. Luke is a solicitor and an advocate, and he's the managing partner and founder of Keaton Harrison LLP. Luke, can you hear us? You'll be talking to us about non-performing loans and distressed investments and how to work those non-performing loans out. Luke, are you with us?
I hope you can hear me. Fantastic. Well, assuming you can hear me, I shall start. And I'm sorry I can't be there with you in Nigeria today. The cost of even an economy flight on British Airways was about £2,800 and would have probably bankrupted me had I come in person. So I shall be attending remotely. I do have some slides, and I'd be grateful for the assistance of those in the room to put the slides up on the screen, and I may have to adopt to the famous slide moving cue adopted by Boris Johnson during COVID of saying, next slide, please, as we move through the slides. Thank you. So I'm going to be talking to you about the strategies for dealing with non-performing loans and as an adjunct to that, distressed investments, and a lot of the strategies do overlap. The three areas I'm going to cover are first of all assembling the right team, and as we will see, the right team is not always a team of just lawyers. Secondly, the use of civil and commercial proceedings, and thirdly, the alternative use of insolvency proceedings. And each case really requires the parties to look at the strategy at the beginning and decide which sort of proceedings is going to be the right way forward. Can move to the next slide, please. I think Amici has done an introduction, so we can skip this slide. So the first question you have to ask yourself is, who are you going to call? For those of you who grew up in the 1980s, it's not the Ghostbusters. The first person I normally call when instructed on an asset recovery mandate is an investigator, because essentially our job is not just to get judgments, our job is to recover assets and recover the money for our client, whether it be a financial institution, private equity firm, or high net worth individual. And the investigators are key to enabling us to identify what assets the target has, where those assets are located, etc., using a vast range of tactics, including many online sources, But in big cases, we will have people on the ground going to various different jurisdictions, sometimes embedded within the community where the targets live to get the best information about their lifestyle and assets. The second part of the team often is an insolvency practitioner or forensic accountant, because very often assets are monies that have passed between the debtor and third parties and moved around, and want to try and track back those assets. If we could go back to the last slide briefly, please. And insolvency practitioners and forensic accountants are very well placed to ascertain exactly where the money's got and identify potential claims that may be brought against third parties at the end of the process to claw back those assets if they're no longer in the control of the debtor. And of course, the third area is the legal counsel team, both locally in the jurisdiction where the debtor perhaps is based or where you've got jurisdiction over the debtor to sue them, but also in the various jurisdictions where the debtor resides or may have assets, because you're going to want to ascertain right at the beginning whether you're going to be able to get a judgment recognised there and enforced in those jurisdictions, issues around servicing proceedings of individuals from those jurisdictions. For example, it's actually a criminal offence in Switzerland to serve other than via the proper intra-government channels. So you want to get that sort of thing right. So moving on to the next slide, I'm going to consider civil and commercial proceedings. And the starting point is obviously targeting the borrower and the guarantor, what I refer to as a direct targeting strategy. And in order to do so, you've got to, as I mentioned earlier, know where they're based, what assets they've got, and understand the key issues in those jurisdictions that they're based in, that will assist you to enforce any judgment that you obtain. We often find in these cases, particularly in cases arising out of bank guarantees and such like, that one of the common issues we come across is allegations of forgeries of the alleged guarantee and that sort of thing. So it's important to gather evidence early on to establish that those sorts of challenges are far-fetched, etc. So evidence from the witness, from the guarantee, or evidence from internal records showing the document coming into the bank or financial institution. And then at this stage, it's also important to take a step back and consider whether actually you want to go down the route of suing the debtor or opening in domestic proceedings, insolvency proceedings, whether it be bankruptcy or corporate insolvency against the debtor, is the right way forward. Move to the next slide, please. So, in the context of England, and there are a lot of cases where there are debtors where the debt arose in Nigeria and the debtors have assets in England, so the jurisdiction comes up very often. There is no treaty that enables a paper-based application to the court to recognise a Nigerian judgment. So you have to rely on the common law approach, which means that the judgment must be final and conclusive at the originating court, assuming the Nigerian court has jurisdiction, and free of fraud. And there's no other public policy reason as to why the judgment should be enforced. And actually, the English courts are, including in the case of Deepening, grappling with whether or not proceedings in the originating jurisdiction were fair for the purposes of Article 6 of the Human Rights Act. Even for countries that are not signatories to the European Convention on Human Rights, because it's arguably a public policy consideration in England and Wales that the judgment was paid fairly. And the proceedings are what's known as Part 7 proceedings. Often you can get a summary judgment, without full trial and disclosure and all that sorts of thing. But these things do involve suing somebody, they're often defended, and they are not always tuned to a conclusion. But once you've got some recognised judgment of a foreign court, you can rely on the English judgment in that regard to enforce it in a normal way. So we're now going to the next slide and at the worldwide freezing orders. So freezing orders are a well-used tool of the English court in multi-jurisdictional international asset recovery. And they freeze the debtor's assets around the whole world using the penal consequences of the English court if the freezing order is breached. Not totally harsh, they also contain information from the debtor about their assets, which have to run under affidavit, and if they do not do so, or do not do so honestly, they can be subject of contempt of court and imprisoned. And that can involve arrest warrants being issued, meaning if they come into the UK, they get picked up at Heathrow and taken to prison. What you have to show in order to obtain freezing orders is a good arguable case, and there's a real risk of asset dissipation, and it's just inconvenient for the court to grant the order. And you have to show that is the case of unpaid guarantee debt, where also added to that you've had maybe dishonesty of the guarantor. You've got evidence that the guarantor is moving assets around. He's put his house in his wife's name or something like those lines. The business failed, and that gives you a risk of dissipation. And as I mentioned, this doesn't just extend to assets in England and Wales. If it does, and there's a real estate or something like that, you can actually get the freezing order registered against the property. But if there are foreign assets, then the penal consequences still kick in. And the worldwide freezing orders are principally designed to deter debtor from fraudulent transfers and preserving the assets until you get your judgment. So we're now going to look at insolvency proceedings. We can go to the next slide, please. Thank you. And section 423 of the Insolvency Act. Now, this arises both in insolvency proceedings, but can also be brought as an adjunct to civil and commercial proceedings. It allows you to challenge the transfer of assets out of a debtor's estate in circumstances where it's intended to put the asset out of reach of creditors. And it allows you to target third parties. It may be a family member, it may be a business associate who receives assets from the debtor. And it involves transactions not only where they were gifts, but where they were of some other value. What's key in section 43 is you have to show an intent. So you've got to use the Latin, and you've got to show the mens rea, the intention to put the assets beyond the reach of creditors, and that has to be the intention of the debtor. It doesn't matter what is intended by the recipient of the asset. So we sometimes see these being tagged on to claims to enforce foreign judgments. I know that Michi's firm been involved in quite a lot of these cases where they have also brought section 423 claims, as you'd expect. So looking at the alternative now to civil and commercial proceedings, we're going to look at insolvency proceedings, and in particular recognising foreign insolvency proceedings. Could have the next slide, please. Thank you. So you have this strategic decision to make at the beginning of the case. Do you want to go down the insolvency proceedings or judgment enforcement? And if you've got the ability to bankrupt the debtor in the home jurisdiction, so say in Nigeria, then you may be better to go down that route and get your bankruptcy order or your liquidation, etc. And then come to England for their assets in England, real estate or bank accounts, or potentially people who have received money in the sort of circumstances I was describing earlier, where potentially that money can be brought back to third parties. So you take your Nigerian bankruptcy, you come to England, and we have adopted the Amsterdam model law on cross-border insolvency in the 2006 cross-border insolvency regulations. And we're a particularly friendly jurisdiction to recognising foreign insolvencies. They've essentially got to be proper collective insolvency regimes like bankruptcy, like liquidation, etc. Those sorts of regimes will readily be recognised by the English court. And what that does is allows the foreign office holder to start dealing with the assets in England as if they were the debtor. A trustee can essentially be appointed to also deputise in those circumstances, and it's a strategic alternative to the litigation because it, as well as getting to the assets potentially more quickly, you also unlock a toolkit. So we're going to move on to the next slide and look at that toolkit. And I have to apologise to everybody for the use of gavels in these slides. The pictures were given by somebody else. I have to say in England, judges do not use gavels. So I just want to draw your attention to something you do need to be aware of when you are seeking to open insolvency proceedings in England and Wales to essentially enforce maybe a judgment that's been obtained in Nigeria. You do still need to get the judgment recognised first, the process I was talking about earlier. And the reason for that is the recent case, Court of Appeal decision, which reversed a High Court decision of Service Terminal and Drell, a case I had some involvement in. And the English Court of Appeal essentially says, reaffirming the NDIC Rule 45, which is a rule which governs recognition of foreign judgments. Foreign judgments have no direct effect in England without formal recognition. So even though a foreign judgment creates a debt, it needs to be formally recognised before you can then petition somebody's bankruptcy based on that debt, which is why opening insolvency proceedings at the home jurisdiction and using cross-border insolvency to recognition is often a quicker way to get to the assets. So finally, we're going to, I think, look on the next slide at the tools that are available once you've been able to get. We can go back to the previous slide just for a second. I think I've covered everything there. So we get back to the toolkit. This is the challenge of not having my finger on the button of the clicker myself. But once an insolvency is recognised in England and Wales, you have a hell of a lot of powers that and each of these teams are be very used to utilising, including powers to examine witnesses and obtain information, documents, etc. So family members of an individual bankrupt or former members of staff of a corporate insolvency, getting documents from banks, all the professional advisors, law firms, accountants and that sort of thing. You can understand how that's going to be very helpful in trying to get to the assets. But then the English recognition procedure also opens up all of these clawback claims. So if there has been a transaction that's undervalued, if there's been a preferential payment or anything like that, those claims can then be pursued in England and potentially bringing some very significant assets into the estate. It also has the effect of stopping other creditors from going after those assets. So once you're recognised, if the judgment debtor has got other creditors, they can no longer enforce against those assets because they have to step in line and prove in the insolvency that has been recognised. And that's helpful because it stops the asset being lost to a third party. So it's a very powerful set of tools and one that is certainly worth considering in cross-border asset recovery cases. We go to the next slide. So I think that covers everything I actually wanted to say to you today. But I'm very pleased to take questions if anything arises from this address. Thank you. Thank you.
Luke, thank you for that presentation. We'll come back to questions later. So if you just want to stay on the line. So we've heard from Luke about how to deal with toxic assets or non-performing loans. Toxic assets are, you can think of them like your in-laws. Should I stop there? I think I have my family in the room. Well, they're exactly like your in-laws. They're a necessity. They linger around, and you have to come up with coping strategies to deal with them effectively. Now, another matter that we're going to touch upon today is NDIC, and I think this is going to be very, very topical because there's been some developments in the law that touch upon the people in this room. Some of us were affected by matters related to Heritage Bank, which went bust a few years ago. In fact, some people said it was all in the name. Heritage had no future. So maybe we just start looking at the names of our banks. But it's left us with a heritage of, learning points, developments, and various ways in which the framework has, been enhanced since those days. So I want to invite on, Mr. Oladipo to come up and give us his talk for 15 to 20 minutes. And please, please, please keep submitting those questions to us for later on. Thank you.
Good afternoon, ladies and gentlemen. Please permit me to stand on existing protocol. And I bring you warm regards from my MD, Mr. Sunday Oludari Thompson. Thank you very much. What do we do in NDIC? We're actually the third leg of the financial safety net. The first leg is financial regulation, supervision, then the CBN, which is the lender of last resort, and then deposit insurance. And then what is our mandate, really? Just a prelude to what we'll be going through. What we basically do is deposit guarantee. We do bank supervision. We do resolution, failure resolution, and liquidation. And what is the essence of all this is to ensure financial system stability, to guarantee depositors' confidence in the system. And this is more so important because of the financial mediation role the banks play in the system. So for a viral economy, it is very important that the banking system, which is more of the depositors, are protected and are secured. So that is basically what we do. And then before we get to this, and we know that depositors are very, very important. The bank takes money from the surplus sector and then to the deficit sector. So they are doing a very risky business in terms of taking from here. So when there's a shortage from here, it affects the other parts. And then that might lead to bank failure. Coupled with the other things, we have the endogenous factor and the exogenous factor. There are factors around the environment, the economy. We know the economy is not very wonderful right now. It can affect banks. And then we have the ones that are internal, corporate governance issues, boardroom squabbles, insider-related loans and advances, non-performing loans and all that. So these are things that culminate in a failure of a bank. And then that is why we have, like I said, one of the major reasons for the financial safety net is regulation and supervision. And then for banking to be very effective, it's one of the most regulated businesses in the world. And then there are legal frameworks for bank resolutions because of this important role banks play. And those legal frameworks is NDIC Act 2023 is one of them. The BOFIA, Banks and Other Financial Institutions Act 2020, the Central Bank Act 2007, Companies and Allied Matters Act 2020. Then we have the Failed Bank Recovery of Debt and Financial Malpractices in Bank Decree. We have the Asset Management Company Act 2010. You have the Sheriff and Civil Processes, dishonor checks, and a whole lot of other regulations that help with insolvency. And then the Act makes NDIC a sole deposit insurer in Nigeria. So, and then there are lots of other sections. I'll try to be very fast because I know BRIPAN is very, very effective when it comes to time. So we look at section 49 of the Act, and it said that when a bank is unable to meet its liabilities or persistently suffers liquidity deficiencies or its losses has been shareholders' funds have been eroded by losses. And I'm going to explain this in a way because for banks, some banks can go on working, but their shareholders' funds could have been eroded by losses, which means as depositors come in and bring in money, they can keep on working, but technically they are already technically insolvent banks. They may not have money because particularly when you see aggressive marketing, people bringing in money, and the bank is liquid because depositors are bringing in money, but they are supposed to trade on the shareholders' fund. It's on these funds that they are supposed to make provisions for losses incurred. Losses are not supposed to be provided for or covered by depositors' funds. So that is when the regulatory authority comes in to check. When we do supervision, NDIC has extended mandates in that we can do bank liquidation aside deposit guarantee, which is the sum we pay. So when we go in and these banks are technically insolvent, one of the things to aid, which is the bank resolution functions that we do, we give financial assistance to banks, we give them accommodation facilities, and there's a whole bouquet of legislations on all this. And most of these resolution activities, either we do some alone, now we do them with the new enhanced NDIC Act, CBN Act, we do them with the concurrence of the Central Bank of Nigeria. And some of these resolutions include, with the concurrence of the CBN, is for them to rationalize their branches, right size, take other nations, they can merge, they can do assisted merger, they can be told to stop opening of branches, something to trim down operations and save costs in a way to make them go back to profitable business. So, and the CBN itself, when the bank is now totally, the funds have been totally eroded by losses, to guarantee depositors' funds, the banks can be acquired for a nominal fee, and the NDIC could be given over to resolve it. And part of the resolution measure is we do bridge banking. If you look back, you notice that we had AfriBank, which became Enterprise Bank. We had Sky Bank that became Polaris. These are bridge banks. The essence of the bridge bank is to float another company, acquire the insolvent bank for a nominal fee, and get a shelf company like a bridge bank. So go on, acquire. We do what we call a purchase and assumption, that we purchase the assets of those banks, give them to the assuming bank, which is a bridge bank, to run it for a while. And if it runs that company for a while, the essence is to get new investors to acquire them. Or if it's supposed to run for a period of 2 years with an extra 1 year. A bridge bank is not supposed to last for more than 3 years, according to the law, before we find an investor. And it has its advantages. It protects the employment of the staff. It keeps banking business in the community where they are. We're trying to do more of financial inclusion, get more people into the financial safety net, particularly young and hardworking Nigerians, to be able to have access to credit. So Bridge Bank is one of the mechanisms that actually protects banking in the area they are. Instead of liquidating the bank, at least the bank is there until they get an acquiring bank, or they are able to shore up their share capital. So also, we're still going on. I've talked about Bridge Bank, and so when all these resolution measures have been exhausted, They've tried mergers, they've tried streamlining branches, reducing staff strengths, reduction on loans and advances, provisioning and all that. The only result that is left now is liquidation. This is the last resort. It means every effort to resuscitate the bank had failed. So what the CBN does is basically to revoke the banking license of the bank and hand it over to NDIC to liquidate. And when we liquidate banks, we're guided. One, like I said, NDIC is one of the financial safety nets. Our priority is depositor payment, because when we guarantee depositor confidence, we ensure confidence in the banking sector. People can bring in their funds and they are sure they can close their eyes that they will get their money. So once the priority of payment, which is guaranteed by BOFIA and by the NDIC Act, is payment, our first charge is to pay depositors. The money we pay depositors, recently we increased the deposit in short sum to 5 million and 2 million. 5 million for deposit money banks and 2 million for MFBs. And then, well, some will say, why 5 million? There was actually a survey that was done, and they realized that a larger percentage of Nigerians, over 90%, had less than that 5 million. So if the bulk, the majority of Nigerians are actually covered by the 5 million. The few that are not covered are mostly the very enlightened, financially literate Nigerians. They can always see the sign, but the essence is to provide low depositors and ensure that the market women and everybody, including you and I here, to make sure we get our funds. So we have priority of payments, and we must, and the law says that the money, the insured sum, is actually paid from a deposit insurance fund. And once we pay this one from our own fund, then the uninsured, so if you have more than 5 million, you'll be paid from the realized asset of the bank. It's not as if you are losing the entire funds, but your money will be paid from the realized. So when we sell the assets include the risk asset and the physical asset. The risk asset are the loans and all that. When we sell all these ones, then we pay the uninsured from the realized asset of the bank. So, and before the liquidation, there's a new innovation in the Act, which is the voluntary winding up. Hitherto, we did not have voluntary winding up because it was not envisaged that bank would go into voluntary winding up. They are licensed by the CBN. The license will be revoked by the CBN. And when they are not interested in the business, they hand it over. But then, like we said, banks are company first and foremost. They are registered under the Companies and Allied Matters Act, so they can do voluntary winding up. So when the bank realizes that they are not able to continue as a going concern, they ought to inform the CBN and go into voluntary winding up. And the bank will be handed over to NDIC to liquidate. And it is a criminal offense, actually, for a company to do that without informing the authorities. So once a bank starts the voluntary winding up process, the corporation is the one to take over and realize the assets. Like we said, depositors are priority. The law states people in ranks of priority. After liquidator is the liquidation expenses, which we only do, then staff loans and advances and judgment creditors. So, and what do we remove from, okay, I won't go this one because of time, the things that are excluded from insurance insured sum. We know interbank placements are not insured, they're exempted. Accounts held in the same rights and capacity. If you are Kushimo Olufemi in Union Bank, a savings account, you are Kushimo Olufemi in Union Bank in current account, you are Kushimo Olufemi in Union Bank in a fixed deposit account. These accounts are held in the same rights and capacity. They will be joined together to come out with a maximum insured sum of 5 million. Thank you. So one of the reasons, so there are lots of because of our experience, we've realized in the process of it, it's a very tough game realizing these risk assets, because like I said, the uninsured sum will be paid from the realized asset of the bank. So how do we realize this? First, we have to realize the fact that the bank went into liquidation because they had problems recovering these debts. So, and then most of it are always insider related. And then we have provisions, which I'll talk, if I still have time, I'll go on that. And so it's a very Herculean task, but the new NDIC Act came up with a bouquet of legislations, which is based from the experience we've had to help in the recovery of these debts. And we know we now have right to foreclose. We can use the GSI. If you are owing any bank if you're owing a bank in liquidation, we can trace your account and recover the amount. We can apply to the court to freeze your account if you are owing. We can commit a going concern, an obligor, to receivership and wind it up. When we make a demand for this amount and you don't pay, we can commit you to receivership and wind up the affairs of the bank, of the company, of the debtor, to realize the risk assets. And then there are a whole lot of bouquet of those, like I said. Then another new introduction is the parties at fault. We have most of our operations are guided by the International Association of Deposit Insurance, IADI. And one of the core principles, which is principle 12, is dealing with parties at fault. You know, like we said, there must have been a reason why the bank failed. And most of the time, they are always within the bank, insider-related dealings, bridging the single obligor limits, loans without conflict of interest, without declaring the interest in, and the loans are not performing. It's actually a criminal offense under BOFIA. If you grant insider credits, you don't declare it, or they are not performing. So we realize that, so we now try to make parties that are responsible for this failure of this bank to be accountable. So we work with the Financial Malpractices Investigation Unit to investigate these infractions and bring the perpetrators to book. And then one of those reasons of those recovery of those debts, that why we've not been able to pay the uninsured portion, is the fact that realizing these assets can a little bit, like I said, Herculean. Because first, the laws, we know when you want to foreclose a mortgage, now the law says we can foreclose, we can sell, we can dispose. But then you know there's a whole lot of laws that goes around it. So it's and most of the time, most of these facilities are granted without adequate collateral and documentation. Like I said, most of them are insider-related accounts. So getting documents when we go to courts is a burden of proof. They will say in civil evidence is preponderance of evidence. So how do you get this on where there are no documents to prove that somebody actually took a loan? You know, so, but like we said, like one of the innovations is like we do bank supervision. In the process of the supervisions, once we record the infractions of the loan in our examination reports, the law now says that it can be used as a proof of debt, of the debt of what you are owing the bank. So there's been a lot of innovation and improvements on the NDIC Act. Once a bank license is revoked, like we said, one of the speakers said, it's a lot of problems, because if you know of what happened to Savannah Bank, immediately the license was revoked, the shareholders took us to court. Triumph is still in court. We're battling with the shareholders, even some MFBs. So the new NDIC Act now says that even when the court in Savannah Bank restored the license of Savannah Bank. So as it is now, Savannah Bank is a going concern. But with the new NDIC Act, the court can only give award damages. You cannot give restorative order. You can only award damages. Even when you claim as a depositor, as a shareholder, you are only entitled to damages, not restorative orders. So, and then NDIC, because of the peculiarity of the banking business, we've been excluded from the winding up rules of CAMA. And yes, it is in CAMA that once a bank is in liquidation, no attachment, securitization on the assets of the bank can start. That has been replicated to in the NDIC Act. And another innovation, yes, CAMA has it, that once once a company is in liquidation, a liquidator can revisit
for the past 2 years what has been done if there was any case of asset stripping. But the NDIC Act made it 5 years. So we can go back. A bank is in liquidation, we can actually go back and look at what has been done in the last 5 years. Anything that was sold without we can avoid transfer of assets and all that. Another thing we do now is we have the asset resolution company. We want to pay off depositors, but liquidation cannot go on forever. So we have an asset resolution company that once we've recovered and paid to a large extent, so we can terminate the liquidation activities, we send the remaining residual assets to ACO. And that is contained in Section 74 of the NDIC Act. So, and BOFIA, that's BOFIA too has something similar with resolution of a failing bank. And under BOFIA, if you look at Section 34, it describes what a failing bank is. And Section 35 says when CBN can intervene. And like I said, the BOFIA has a full bouquet of resolution activities. And then Section 44 means that suspension or contractual termination. So CBN can actually terminate when it's resolving a bank, can terminate any contract that is onerous on the bank. And they have asset separation tools under Section 41, which empowers the bank to transfer assets of a failing bank to one or more private asset management vehicles in order to manage and maximize their value for eventual sale or winding up. We have sale of business tools, Section 42, which empowers the CBN to sell the securities, assets, and liabilities of a failing bank to a third party, having taken responsible steps to obtain commercial value in the circumstances. We have the bailing. Okay. So we have the bailing. We have the bank. I must talk about the Banking Resolution Fund. One of the innovations of BOFIA is to establish a bank resolution fund, and the tribunal is very important and to help with a lot of resolution in the industry. The Bank Resolution Fund is a fund that's been established by the CBN to resolve banks, and CBN is mandated to pay 10 billion and NDIC 4 billion respectively on the first business day of each year, and banks are required to pay an annual levy equal to 10 basis points of their total assets based on the previous year's audited financial statement. And we have the credit tribunal to be established by the CBN. It means we know our regular courts are fraught with long adjournments, delays, and all that. So the CBN Act, BOFIA, has established a credit tribunal, a tribunal that the banks can go. I know AMCON had a special court that was trying accelerating AMCON cases, but now if CBN hopefully will do the implementation of this tribunal very soon, so we can actually have accelerated hearing of fake bank cases. And then I've already talked about the dealing with parties at fault. This is very important, and I know you all interested. All the banks in liquidation, including heritage banks, were actually looking into it. In those days of the Failed Bank Tribunal, let me just mention the Failed Bank Tribunal briefly. The Failed Bank Tribunal was very effective in debt recovery because sometimes it dispenses with a lot of things the regular court will do. You can do trial in absentia then. You can, once you know, you can place a protective order on a property of a debtor and all that, and it has been very, very effective. Criminal proceedings and prosecution over the years have proved to be a very effective tool in debt recovery. And that's basically all that it is to. Thank you very much.
Thank you very much for that very, very comprehensive presentation. Please, the whole benefit of being in an audience like this is to make it as interactive as possible. So I do want to ask one question each to the panelists, and we've had those questions coming in. So apologies if your questions cannot be asked. But I think we will start with controversial tax. Tax was very controversial earlier, so we'll start with tax. Two very quick questions. Practically, as an insolvency practitioner, can I net off tax liabilities from tax assets of a company, or does the type of tax matter in terms of the ability to net those amounts off when I'm looking at the statements of affairs? So that's the first question.
Okay.
Second question is, in a liquidation or a winding up process, what happens to unrealized foreign exchange losses on foreign debt forgiveness? Because these are just paper profits. So, does that tax get charged to the company, even though the realization is not real?
Okay, thank you very much. Taxes goes into different accounts, some to the federation account, some to special account and all that. So the role, even though under the new law, what has been done is to find a way where such net off can be possible. But of course, even when you want to claim a refund from the tax authority, you don't get those refunds direct from the tax authority. It has to be provisioned for by from the accountant general. So you don't get those refunds from the tax authority. And that is why it's always very difficult for you to maybe use your VAT refund to offset withholding tax, or use VAT to offset company income tax. It's always going to be very difficult. But with the current arrangement, where we are having the single window arrangement that is likely to commence in January, it is possible for you to have your record with the tax authority where such setup may be possible. But for now, until that single window is triggered and it's operational, that's clients are always asking for that. But that's the main reason some monies go straight to the subnationals, and then not all the money belongs to the federation, to the federal government. There's a distinction: federal government, federation, and all that.
Okay, thank you.
Okay. Then two, in terms of see, it is just an accounting recognition, particularly where you have cross-border, debt forgiveness, and you have already provided in your books that so much is outstanding. Okay, and you have used that to determine what type of profit you have reported, on which you have paid tax, or on which you have excluded or avoided tax in the past. So if such indebtedness is now waived, automatically, if the auditors, you have first problem with the auditors, because the auditors will treat it as what? As income. They will recognize it. The question we even had, the dispute you have with the auditor before, is either to treat it as normal income or to treat it as just gain. But with this new law that have now synchronized the rate of tax for both corporate and capital gain to be the same, either 25, we are hoping for by January, or currently 30%, it does not make any difference.
Okay.
So you should still be made to pay tax.
Okay, thank you. Thank you very much. Luke, I think Luke is online for us. If we can just bring him back. There's a question for you here about worldwide freezing orders. Now, you get a worldwide freezing order in a jurisdiction like the UK or the US. And the reason you do that is because there's a better chance of enforceability across the world. Now, the burden of proof that you need to reach to get a WFO is very high. They're very expensive, very costly processes to go down the route of. So, two questions for Luke. Firstly, who funds these processes? How do you get the funding to fund these processes? And then secondly, how do you enforce a worldwide freezing order that you've obtained in the UK, in Nigeria?
Thank you, Richard. Those are two very good questions. Taking the first one, the funding of the freezing order, I think should be looked at in two ways. One is the actual cost of the freezing order, and in certain circumstances, lawyers in this jurisdiction will act on no fee or on a contingent basis, or work with a litigation funder who may fund the asset recovery strategy for an uplift on the amount they funded, normally 3x. They can't do it for a percentage of the recovery in light of a case called Pankar in the Supreme Court. Or otherwise, the client has to fund the legal costs themselves. They are expensive, and it depends on the nature of the case as to how expensive they are. If it's a straightforward case with a debt owed under a loan agreement and a guarantee, and you know that Mr. X is in the process of selling his house in Belgravia because he knows the claim is coming down the route. Well, that's not going to be too expensive to go to court on that. But I've been to court to get a briefing on 4 hours' notice sometimes with just a handful of papers. It's been so urgent. But if it's a very complicated fraud case, then that's going to involve a lot of work, particularly because there's something called full and frank disclosure, where you've got to tell the court all the bad things about the case. So it can be a lot more expensive. And then the second issue is, in addition to the cost, is actually the risk, because when you go through a worldwide freezing order, you have to give a cross undertaking in damages. So you have to say, if this fault is harm, I pay for that harm. If you're out of the jurisdiction, you may have been required.
Failing. Everybody tries to put their hands in the cookie jar. But 5 years is enough. 5 years preceded, there is no way the bank would have been going through those stuffs. So, and I think it can't be forever. You can't go back. You won't have work to do. You can't, because you are charged with the liquidation. It's just for you to discharge your onerous responsibility or things that are against the bank. So if you go back 10 years, 20 years, you will not have time to do the liquidation activity.
Okay.
I think 5 years is enough.
Okay. Now, my hope is that when directors and executives of banks are found to be wanting, steps are taken to actually pursue them wherever they are, wherever they may hide assets, in order to recover those assets back for the shareholders and for the creditors of the bank. Now, there's another question that's come through for you. Sorry, I hope you don't end up monopolizing the question and answer session. It's a direct question on Heritage Bank. Why was a bridge bank not set up to acquire Heritage instead of the direct liquidation process that was adopted?
Okay, if I didn't say any question from Heritage Bank, I would have been. It means I didn't deliver anything. First, the CBN, like I said, is with the concurrence of the CBN, most of these things are done. If the CBN liquidates, if they gave the license, so they revoke it. They gave the life, so they are the only person that can take the life. And for the bridge banking, like I said, it's one of the resolution bouquet available to resolve a failing bank. There's a difference between a failing bank and a failed bank. A failing bank is a bank whose risk asset ratio is less than 5% and more than 2%. So once it falls below this ratio, it becomes a failed bank. And once a bank has failed, the license has to be revoked. So, and then, like I said, it's the wisdom of CBN. They've looked at it. They have all the details. If the license is revoked, it means they've exercised all the resolution options available. And the last resort is liquidation.
Okay.
Before the assets are further dissipated. So they try to take off the whatever, so regulatory authorities can go in the interest of depositors primarily.
Yes.
And other creditors of the bank.
Okay. All right. We'll take a bit of a break there. I don't know if Luke is still with us, if he's come back. I think he did briefly. Is he online? All right, I saw him pop up briefly. So let's go with another question for Sec whilst we wait for Luke. Now the question is whether a subsidiary legislation like the rules under ISA, I don't know if you consider it to be a subsidiary one but anyway, if a subsidiary legislation like the ISA can be made to override substantive law like the CAMA 2020 in the event of insolvency. And actually, an extension of that, if there's a conflict between the two, which one prevails?
Okay, so first, I guess maybe the framing of the question wasn't very correct because ISA is not a subsidiary legislation, it's a principal act just like CAMA. But I want to assume that maybe the question was actually targeting something I mentioned about the default rules of the FMI taking precedence over the general provisions of insolvency. Then if that is the idea, I may not say exactly how it will work in practice until we get there. But for now, visions a provision of the law. So if the law says this is the procedure that has to be followed, then I think it is no longer a question of a subsidiary instrument taking precedence, but that instrument has been recognized by the law and given that priority or that position. So I think that it will also fly. But until we experiment it, I don't know. That's the default rules of the FMI. Yes, is given priority over CAMA by the ISA.
Okay, thank you. Okay, thank you very much for that. If Luke is back with us, we'll take the question, but if not, this will be the final question. I think we can open up to the audience if there's any questions from the audience. This is about the NDIC Academy, which someone has observed that it offers excellent training, but it seems to be limited to top executives in the financial sector. The comments and question goes on to say that given the central role of insolvency practitioners, especially BRIPAN members in business recovery, are there plans to extend those trainings to them to strengthen their capacity in resolution and related areas?
Hello. Yes. Thank you. Well, one of our strategic directive is a partnership with our stakeholders, strategic partnership with our stakeholders. So we'll be willing and would love to collaborate with BRIPAN on the training, retraining, learning and non-learning global best practices on insolvency. Yeah, that's basically one of our core responsibility is resolution and liquidation. Supervision we share with the CBN. So liquidation is one of our very whatever. So it would be nice to collaborate. And one of the area of collaboration, we're having BRIPAN come to train some of our in-house counsel on to be members of this institute. And I think we're already in talk and discussion with BRIPAN on that. And my management is actually favorably disposed to that.
Okay.
Like I said, I started, he sent his warm regards and best wishes for the institute.
Okay, thank you very much. Thank you for that. A round of applause. Thank you. So Luke is back. Luke, I thought you were strategically avoiding my my earlier question, which was about the enforcement of a UK issued worldwide freezing order in Nigeria. How would you go about doing that?
Well, I mean, that's actually a matter ultimately of Nigerian law and practice in terms of how the Nigerian court would receive an incoming English freezing order. I mean, what I would say is that there are two ways that English freezing orders can be used in practice in other parts of the world. One is simply by virtue of the fact that they come with a penal notice. So very often people who travel around the world, people with wealth, etc., or holding onto assets, but will need to come into the UK. So they think twice about reaching in terms of a freezing order, and that has a practical effect in securing enforcement. But then other courts in other parts of the world, I'm thinking in particular of the Caribbean, the Isle of Man, DIFC in United Arab Emirates, the AGTN court in Abu Dhabi. You know, these courts will readily take an English freezing order and on a relatively light touch basis grant a mirror freezing order within those jurisdictions as well. I mean, we generally see that approach taken in common law jurisdictions around the world. Singapore is another jurisdiction where we see that. So I don't want to sort of profess that I know exactly what happened in Nigeria, but I imagine it would follow a similar common law route.
A comments from the audience, please. Maybe on that particular
Yes,
matter.
that's correct. Yes, my name is Sheya Kiwumi. The truth is that we do have judgment enforcement rules, but those judgment enforcement rules only apply to monetary judgments. The worldwide freezing order is not a monetary judgment. It's a freezing order, as the name connotes. And therefore, I think the only way in which you can enforce in Nigeria is by instituting a fresh action in Nigeria, probably an originated summons, by which you can then say, look, we have this facts, and then we're asking for the specific order you're looking for. And that way, you get it in a roundabout way. But I don't see how you can get it directly from a worldwide freezing order. I don't see it.
You know, we have a lot of clients who are tied up in really expensive litigation in the English courts and elsewhere. They then get to the end of their proceedings, and then they get their paper from the courts, and then they're waving it around and asking us to go and do things in Nigeria that we cannot do. And quite often they have to come back to Nigeria and start again from the start. But it's a painful lesson, but one that I think they always like to learn because sometimes they don't want to listen to proper advice. So please, any other questions or comments from the audience? Got one over there. I'm not sure how we're doing for time. How much time have we got? 2 minutes? Okay. Can we get Mike up there, please?
Sorry. Good afternoon. Thank you very much. So I have a question concerning tax. As it has been clarified this afternoon, you have to have a turnover. I learned that this does not apply to professional companies, right? It doesn't apply to professional companies like accountants, lawyers, or people who are in liquidation. I want to be clear on that. That accounting firm, would they pay VAT if their turnover is below 100
Sorry.
million?
Okay, where's that exemption
I'm
from?
not sure. I wanna
I understand the question.
Okay.
When it comes to VAT, and we're looking at threshold, we're saying that, and the resolution tools worked, it becomes an LD bank. And it goes into the regular banking, all those major restructuring. It doesn't, the restriction on the opening branches. Yes, ma'am.
Sorry, sir. My question is, once it survives,
Yes, ma'am.
all the measures worked.
Yeah.
Is that bank, those banks, are they continuing as the bridge bank now, or do they revert to what they were?
Okay. Like I said, the lifespan of a bridge bank maximum is 3 years. You operate first for 2 years, and there's an extension of 1 more year, based upon which, by a fluctuation of time, it goes off. So within that period, what the regulatory authorities are doing is to get investors to invest into it, and perhaps any of those regulators, they could do a P&A, purchase and assumption. Yes, ma'am. Am I right? Okay. Okay, so they might do a P&A, purchase and assumption, where they get an LD bank to pick. They could do cherry picking, total asset, whatever. So they can still use another. If that bridge banking fails, they can get a will-be shareholder to invest in it. Then they can now liquidate it.
But it's just that after that period, it's just a window whereby they can transfer it to another investor or continue to use other things to make it work. The essence is to make it work. And then there are conditions, circumstances that make the authorities use bridge banking. And then, like I said, it has its own advantages. Maybe in a village somewhere in Ogun State, where I come from, maybe that bank is probably the only bank that has a wider nation reach. If you kill it is for most of the areas, I'm not saying that's the reason. Those might be one of those considerations. Okay, let's keep it, legacy bank and all that. But the issue is, it is a resolution tools to make sure a failing bank gets back on its feet, for an investor to come in. If they can't come in, they use other resolution tools. But after 3 years, but we know in practice, some have exceeded 3 years.
Yeah, but on successful, when the transformation is successful, surely you're bridging from A to B.
Yes.
You're not going back and reversing back to the historical entity. So there's a new co that will come in and take it forward, right?
Okay, yes. That's exactly okay. Okay, so once the bridge bank is fully breached, a new entity takes it in. It's no longer, it wasn't AfriBank. It became Enterprise Bank. AfriBank, the new investors entered and became Enterprise Bank. The Enterprise Bank eventually entered into Heritage Bank.
Okay. No, thank you. I think that's it. We've run out of. Have we run out of time? So I am clearly standing between.
Please.
Oh wow, there's a brave man that's about to say something.
Okay, so I want to take you up on your earlier answer regarding Heritage Bank. You made mention of the fact that it was CBN that stripped Heritage Bank of its license, and you said as at the time NDIC came in, Heritage Bank was already failed. But I'm aware that part of the oversight function, the regulatory functions of NDIC is to review the financial status of the banks. I think it is done annually. And I was wondering why the NDIC did not intervene before the Heritage Bank became failed completely to warrant the CBN going straight to strip it of its license.
Okay. Thank you. Sorry, I think we have NDIC here, not CBN.
No. I would not as
yes, my question is, why didn't the NDIC intervene to come with this bridge bank formula before Heritage Bank became completely failed?
Okay, let's see whose role is it to intervene.
I already make a distinction between a failing bank and a failed bank. Once it is failed, it means its license has been revoked. Like I said, just like God that gives life and take life, CBN for bank, CBN gives the license, which is the life, and it takes it. It is when CBN revokes the license of the bank. It is when the license has been revoked. Once it is revoked, it now becomes a failed bank, not failing. It is now handed over by the law for NDIC to liquidate. Then your question is, why didn't we know it was a failing bank to do all those options and not allow it to fail? Like I said earlier, even the best of plans failed. That's and I said, there are 3 systems of the financial safety net. The first is regulation and supervision. Then the other one is lender of last resort, which is done by the central bank, and liquidation. Liquidation itself is another failure resolution, orderly resolution of failed institutions. That is liquidation. Is another option of making people get their money. So it is not as if liquidation, it's not a very palatable thing, but it's still the way of orderly resolution of the financial system. Like you said, we supervise bank with the concurrence of the Central Bank of Nigeria as per the BOFIA Act. So the CBN is the lead regulator in the industry. That is their primary responsibility. Our own primary responsibility is depositor guarantee and confidence, to ensure the safety of the funds you keep in there. That is our primary responsibility. And when we do the liquidation, like I said, we have an extended mandate. Some deposit insurance in the world are just simply pay box. Once the license is revoked, they just go in there and pay and they are out. But the Nigeria has a deposit insurance system with an extended mandate, meaning we can go in there and check. So we have an idea of the status of the bank. We have an idea of getting records. If you look at the last time we did, the access we must pay insured deposit within 30 days. We did that before the 30 days. If you look at the last Heritage Bank, it's because over the years, and because we've been able to go in there, we're able to take data to pay depositors. So this is, and with BVN and technology, unlike before, when you have to come there, we do depositor verification. Because we do supervision, we have some of this information. So people, if you have accounts in Heritage Bank, all you just need to do, most people just get alerts on their phones with their alternate accounts. If you have not gotten alert on the short sum, we have even started paying liquidation dividend. Liquidation dividend is when we realize some of these assets of the bank, we pay on pro rata basis. So that is what we do. So it's totally different from CBN responsibility. Our mandate is different from CBN. Thank you.
Okay, no, thank you. I think we're going to just, next year, we'll make sure we get the CBN to be in this room and we'll give them their own time and 3 hours, okay? And then we can question them. Now, we've run out of time, but I want to give each panelist 30 seconds only. And if you're not done in 30 seconds, we'll cut your mic. No, maybe we won't. So 30 seconds each, just to summarize kind of where you've got to from your talk today. Please.
Okay. So just in summary, well, NDIC exists to ensure your funds are secured, you are safe. All banks in Nigeria are safe and sound. The CBN is doing a good job regulating this industry. And like I said, even the best of plans fails. So, and that is why we have the deposit insurance. So even when these plans fail, if you look at Emron and all those whatever in the UK, in the US, they've had bank failures. Yes, in those developed countries, they pay immediately less than 24 hours to get your money. But we have to know that we have peculiar situation. We don't have a deep market for loan factoring where we can quickly realize the assets and sell the risk assets, just sell it off and all that. So we may delay in paying the liquidation dividends, but it's just because of the peculiar nature of the environment we work in. But be rest assured, your funds are safe. We pay from our own insured funds. We have different insurance funds for each category of banks, even up to the non-interest banking, because we know that you are not supposed to pay interest. So we have the deposits and we insure non-interest financial institutions.
Okay.
So your funds are safe. Thank you.
All right. Thank you very much. Thank you.
Thank you. I know people don't like to hear tax. The truth is that as insolvency practitioners, we need to get familiar with the provision of the law. It's a wholesale change. We cannot be ignorant as experts. We must guide every area that concerns us as practitioners, either as a liquidator, as a receiver, as an administrator, where that arises. And of course, there are quite a number of provisions that also affect us personally, our pocket. You know, we have quite a number of senior advocates here. Nobody wants to pay tax, but we just have to take care and ensure we are compliant.
Everybody wants to pay tax.
Thank you very much.
We all
I don't want to pay tax.
All right. Okay.
Okay, thank you very much. Mine is in 30 seconds. God forbid that an FMI will fail, but just in case, let's add the new provisions to our toolkit, just in case. Thank you.
Thank you very much. Well said. Short and sweet. Luke, final comments?
In the case of non-performing loans, assemble a multidisciplinary team very early on, local advice, develop your strategy, whether it's going to be civil and commercial litigation strategy or an insolvency strategy. That may depend on the jurisdiction where you're going after the assets. So first rule is, where are the assets?
Thank you. Thanks, Luke. Now, thanks to the audience, colleagues, ladies and gents. Thank you to the panelists that are here. Thank you to BRIPAN. And thank you to the coordinators and my able timekeeper that's been pressuring me all throughout this event. And then I think you're going to say some, so I'm going to say some final words. So.
May I also say thank you to Mr. Amechi Nsofo. Thank you for such a great work you have done. May we please put our hands together for our panelists? It's been a fantastic second session so far, day one of BRIPAN Conference 2025.
Thank you very much to our stellar panel. I just have a few announcements to make. Coptic Hospital Services have a free checkup at the ground floor, so please do well to stop by to do your checkup. We also like to call upon the executives of BRIPAN to kindly join us upstage for the photo ops. Thank you.
May we request the presence of the president, the chairman, past president, members of the council, photo session and presentation of gift. May we have a bit of music in the background as well? Ladies and gentlemen, please put a smile on those beautiful faces as we all say BRIPAN. Fantastic.
Miss, would like to call on Dr. Adebola Olubanjo, okay, FCR, FBR, to make the presentations to the speakers.
That's it. Represented by Mr. Kachi Edegwe.
On behalf of the BRIPAN president and the executive, present this to you and we say thank you. We appreciate you.
Thank you very much.
Where's our president?
Please put your hands
President?
together.
Our chairman, on behalf of the president and the executive of BRIPAN, we say thank you for this your presentation today. Thank you very much.
Got it. That's what I'm saying. Thank you, sir.
We will be taxing you, sir.
I have to be here because of I was calling you so that you can shake your hand, shake their hands. Femi Oladipo.
Shiva.
On behalf of the president and the executive of BRIPAN, we say thank you. Thank you very much.
Thank you very much, sir.
President, please shake his hand.
You have given me already.
We have given him.
So group is not available physically. Thank you, sir. Where is Amechi? Mr. Amechi?
Mr. Amechi, you're needed here. You know this presentation will not be complete without you.
On behalf of our president and the executive of BRIPAN, we say thank you. Thank you very much. Thank you. Thank you. President, please. President. Amici, President.
This thing is very heavy.
Thank you.
He's online.
Okay. Look, we are saying thank you to you on behalf of the president and the executive of BRIPAN. We appreciate you and your contributions. Thank you very much.
Thank you so much, sir.
Wonderful again. Thank you very much. Thank you.
All right, ladies and gentlemen, just to let you know that some of the slides for the speakers, I don't know if all, but I've been informed that some of the slides will be available for you to access. So you basically need to reach out to the coordinators and you get access to the slides. We've just been informed that food is ready, so please don't go. I'm sure you noticed the smile on my face. Dinner will be served shortly, or should I call it lunch, will be served shortly. We also will be sending, please listen, this is very important. Tomorrow morning, a case study will be sent to every participant. So you please check, I think, your emails. You'll receive a case study. You're expected to go through it, read it, understand it, because it will be discussed here tomorrow morning. So as you receive the case study, please do well to go over it and get ready for the discussions that will take place here tomorrow. I do not think that this event will be complete if we do not recognize the person of Mr. Olasuko Ademosu, PhD, Chartered Accountant, Engineer, and Lawyer, aka the Passionate Evangelist. Permit me to say, Daddy, it's a pleasure to have you here. And of course, we want to recognize the person of Alhaji Taufik Lawal, FCA, former BRIPAN Council member and former senior partner at PFK International. We would also like to recognize the person of Professor Sodikpo, SAN, who is here today. It is such a pleasure to have you. Would also like to recognize Mr. Yusuf Yakubu, FCA. Thank you so much. We know you are such a busy person, and it means a lot to us that you're here today. We would also like to recognize the person of Mr. Godwin Omaka, SANABR. Thank you, thank you, thank you. This event will not be complete without you. Please, may we settle down for the third session? May we settle down third session? This session will start from 4 till 7 p.m. Are we ready? I saw the excitement on your face, sir. Don't worry, the third session is menu, menu, menu. Food is ready. I'd like the coordinators to let me know what you want done. Is it packed? Are people going to get it? How do you want it done? Ladies and gentlemen, distinguished ladies and gentlemen, my name remains Chioma Agunobi, media practitioner, public relations consultant, actor, and television producer. It's been my absolute pleasure doing this with you again. I look forward to tomorrow. Today has been so insightful and very educative. And I know that the conversations have already started and will continue tomorrow. And of course, it definitely will not end tomorrow because these conversations are ongoing through the year. With this said, I do not know if there's any other announcement. Mr. Chairman, sir. Mr. Chairman, sir. Any announcements, anything you want said as we wrap up for today?
So let me ask that. Let me put you. Sorry, Yibi. Harry Yibi, please. Harry Yibi, co-chair. Harry Yibi. Harry Yibi.
Media, please bring it down. Media, please bring it down. Sorry.
Mr. Harry Yibi, please come back. Come and give us closing remark as the co-chair.
Good evening, ladies and gentlemen. It's my pleasure to give closing remark on today's occasion. I would like to thank all the speakers, chairman of sections, our president, council members, our distinguished members. Thank you. And please ensure you come in time tomorrow. Thank you very much, everybody.
Thank you, sir. Distinguished ladies and gentlemen, my name remains Chioma Agunobi, and it's been my absolute pleasure doing this with you here, day one. We will be here early day two tomorrow. For dinner, for lunch, please remain seated as the meals will be brought to you on your tables. You will be served on your tables. If you're standing up, you will not get lunch. Ladies and gentlemen, see you bright and early tomorrow. God bless you. Music.